I'd like to call our dispensing optician committee to order. And I'd like to take roll call. Bill?
Present.
Anna?
Here.
Con?
Here.
And I'm here as well. Now I'd like to move, if there is any public comment or anything that is not on the agenda from the public, we'd like to state that now. Okay, so we'll move on to approve the minutes for our last meeting on September 22nd. Do any of the committee members have any comments about the minutes?
No.
I move we approve the minutes.
Okay. Do I hear a second?
Second.
Okay, I'd like to call for a vote. Con? Like to vote? Oh, I'm sorry, public comment, I'm sorry.
Do it after the vote.
Yeah, I'm sorry. Any public comment? I'm sort of rushing through this, I apologize. Didn't put on the agenda? Okay. All right, so now we can call a vote. Okay, Con?
Aye.
Anna?
Aye.
Bill?
Aye.
And I vote aye. Okay, now we move on to the executive officer report. Jessica?
All right. Kelly, would you mind switching to the... So members, actually, I just realized, and I apologize for the oversight, the agenda says that A is the strat plan, but I didn't include the strat plan on my memo. So, not intentional, but it was more to give you an overview of what the action plan was. Shortly after the DOC meeting last month, the following week, we had 4 committee meetings to go over certain parts of the strategic plan to develop the action plan to how we're going to implement it. So there were some items where the DOC would kind of take the lead, and as I think that you all know, that you kind of have already started taking the lead on some of the stuff. Anything that dealt with the RDO program, the DOC is going to help with that. It is available on our website, so I can send it out to you. It's completely unintentional that it's not in the memo. So the outreach campaign, it pains me to say that we have not done very much on this. We had the meeting a little over a month ago, and then we had those 4 committee meetings. We have a board meeting tomorrow. We have a stakeholder meeting, and so it's been really busy this last month and haven't made much progress. However, we are going to meet with DCA next week to go over the outreach plan, the timeline, and start disseminating all the materials that the committee had requested. With the occupational analysis, the committee reviewed the proposals from the last meeting and decided to proceed with, recommend to the board that they proceed with occupational analysis of both, with one of them taking precedence over the other. And we wanted to work with OPS to find out as soon as they would be able to do the occupational analysis. Unfortunately, due to their resources and the staff that they have, they wouldn't even be able to start scheduling the OA or even discuss scheduling until next fiscal year. So as soon as they're available, they know that it's a high priority for us. So as soon as we can get on their calendar, they'll proceed with it. Any questions with those?
Yeah, I have a question. When you say as soon as, are they at least giving you the month January, February, or anything like that?
So it's going to be next fiscal year. So we're looking at the discussion starting July 2018. So it's going to be a while.
And that would be for the NCLE first.
Correct. Yes.
And then, of course, we are going to take this to the board. They have to first approve that this is going to go to as well.
Right. So it's just a recommendation that the DOC made to the board to proceed with it. It is in line with the strategic plan, though. It's on there as one of the things the board wanted to do was proceed with the BCP to do the occupational analysis. But we don't believe a BCP is necessary because if we time it right, we can work with the budget office and absorb the cost. So while we're not proceeding with a BCP, it still is in line with the intent of the strat plan. All right, so members, the next 2 sessions we have enforcement and licensing, and these are what we provide to the board members each board meeting, but I thought it helps to be beneficial to have you see it because it shows you the progress for each program, both optometry and the RDO program and enforcement. This enforcement update, actually, I want to thank all the work that Cherie has done. She's our enforcement lead. She has provided not only an analysis of the pending caseload, the work that we've done so far, but she also created some additional statistics. She provided some pretty good comparison. Kelly, would you mind just scrolling down to the table, the charts that Cherie had done? So those are side by side, so you can kind of get an idea of the caseload for optometry versus the RDO program. And right now, the RDO program is being absorbed by optometry as far as case work goes. I do want to say that we are working, Rob actually isn't joining us today, and he's working in the office. And we're working on taking that position. We have a 0.5 office technician and a 0.6 special investigator for the RDO program. I think I mentioned it before that those are really hard positions to fill, and there wasn't a lot of thought put into what those positions are going to do. So the thought is we're going to combine those into one SSA position to do the enforcement caseload. So that's in the works right now. But what I wanted to do, members, is to provide more of an overview of what enforcement looks like and the process that we follow from start to finish, because I think that'll also help give a good foundation when we talk about the disciplinary guidelines and at what point the disciplinary guidelines are put into place. So with that, I wanted to turn it over to Cherie. I'm sorry, Cherie, you want to come over here? I just realized probably have not a great place that I could.
So before I begin with the investigation process, any questions about the statistics or the charts?
So it looked like the vast majority was unprofessional behavior. What's the?
For RDOs, the majority of the cases that we get are actually for unlicensed or unregistered practice. Okay. The second largest is for criminal charges. So somebody who has been fingerprinted and either has previously been convicted or gets convicted subsequent to being registered with the board.
So if you look on the chart, the RDO site is on the left, and the yellow is the unregistered and unlicensed practice.
So what are a couple of the typical scenarios for an unregistered practice?
It can be that an RDO is operating without a registration at all, or perhaps maybe a spectacle lens dispenser is operating without having been registered. It may be that it's like a chain where they've got one store that they registered, and then in the process of opening the second store, they haven't gotten that registration yet. Maybe it's somebody who's new and didn't realize that they had to be registered, or cosmetic contact lens sales, yes.
So on the first two, is the experience that there's, I don't want to say malice, but like that people are trying to skirt the law, or is it that like with the different type of registrations or certifications or whatever, they think that they're doing it right and they're just not doing it right?
I think it's going to be both. It's going to be people who maybe are not doing it with the best intentions, and some people just don't realize that they need to have all of the registrations. They don't realize that they haven't gotten all of their ducks in a row. But yeah, sometimes there are people who just aren't interested.
So of the 50, or however many it is, like, you know, obviously it's a general statement, but like how many are like bad guys? Like people who are like cheating and knowing they were cheating, or like you know what I mean?
So my experience in talking to people that I've talked to and in trying to get compliance with the law is most of them want to be in compliance with the law. So I don't really hear a lot of people who are just like, no, I don't want to do that. And you know, it could be that they're just, that's what they're telling us because we're the board. But yeah, for the most part, the people that I've talked to want to be in compliance with the law.
Well, it sounds like as we increase our outreach and awareness and all of that, those
Hopefully, yes.
should come down. The ones that won't come down are the Halloween context people who are, or swap meet vendors. People were just.
And that's really why we do it. These cases it's a case-by-case basis. We look at that, and those who, where it's a willful disregard to the law, we do citations for, and as you'll see, we issued quite a bit to one entity for unlicensed practice, and it was just a willful disregard of the law. But if there are ones who just genuinely didn't know because of the confusion, we would issue an educational letter. But if they did it again, so say they let it lapse and then they continued to practice, then that could rise to a different level.
And where are most of the complaints coming from?
Like
Consumers? Yeah.
Most
Who's
of them from people who are in the industry.
Okay.
And so they know enough to know that this entity should be registered, and they go and look them up and can't find them.
Gotcha.
By that, do you mean competitors?
Competitors, optometrists sometimes, but yeah, other RDO registrants, people in the business generally. So for just like generally about the enforcement process, we get complaints and initiate investigations based on a number of things. For the RDO program, most likely they'll come from DOJ or FBI, which is how we get our criminal conviction information, or consumers, stakeholders, which is how we find out the unregistered, unlicensed information. Not so much the insurance companies for RDOs, but sometimes consumers, depending on what the issue is. We receive an average of 380 cases every year. And the most common allegations: unlicensed or unregistered practice, criminal convictions, advertising violations, personality conflicts, pricing, and misdiagnosis or failure to refer. Once we get that complaint in from however we get it, yes.
So these 300 and whatever, these are against RDOs or dispensers?
And optometrists.
Right.
And
so for the
optometrists.
whole optometry program,
Right,
yes.
because the former aren't diagnosing.
Correct.
Anyway, got it.
Correct.
The first chart that we have, it breaks it down of the types that we get.
That's what we're referring to. Got it.
Yes.
Got it. It's the whole enforcement program on
Yeah.
the board.
Correct.
Understood.
So once we have received the information that a person who's under the board's jurisdiction might have committed a violation of the law, the first thing that we do is we kind of look at that and determine if we have jurisdiction over this person. Sometimes we get complaints against ophthalmologists or people who are not licensed or practicing in California. Various other things that we would not have jurisdiction over, we refer those out. Then we kind of determine if it's something, if the issue is something that's potentially a violation. If it comes down to, say, they're saying, I got eyeglasses here for this price and I have the same ones over here for this price, it's way more, and we don't have really regulations that deal with how much you charge for something, so that's not something that we would necessarily have jurisdiction to take action about. Once we've determined that it's potentially a violation, we do have jurisdiction, it gets opened and assigned to an analyst who then starts gathering information from the complainant, from the subject of the complaint, sometimes from other parties, particularly with optometrists. They may have seen a secondary optometrist or somebody beforehand that we can also get records from and kind of get some more information. Sometimes we send cases to the department's Division of Investigation so that they can have a field investigator go out and interview people, maybe conduct an undercover operation, obtain records, subpoena documents if they need to. And once we have everything all of the documentation that we have to get, and we've talked to everybody and kind of gotten the case together. Mostly for optometry cases, we may send them to an expert witness to review them and give us an opinion for standard of care issues. And once we have all of that, that's where we kind of decide whether we're going to close the case with no action, if we're going to send an educational letter, if we've been able to bring the subject into compliance, or if we're going to issue a citation or send the case to administrative hearing or for administrative action. If we close the case because we were unable to prove a violation or there was no violation, we will notify the parties that we've spoken to, and we do retain the case per our retention schedule. Thank you. So that way, if we have a subsequent complaint regarding the similar issues, we can kind of maybe combine them sometimes. If we have, like for example, if it's a case where it's an unregistered practice or an unregistered person and they have gotten their registration, they've come into compliance with the law, that's the point at which we would send an educational letter that says, hey, you were in violation of this, you came into compliance, so we're closing this without action, but consider this a letter of education, and if it happens again, we'll pursue the extent that we're able to under the law. For a citation, that would be for somebody who either this is the second or third time that we've talked to them about the same issue, or they have committed a violation of the law that doesn't rise to a level where taking action against their license, disciplinary action, would necessarily be appropriate, or as a tool to help bring them into compliance. So we would issue a citation. It's an administrative action. It usually comes with a fine. They have appeal rights, so if the subject is objecting to it, they can appeal that. And it stays on the public record for that licensee or registrant for 5 years after it's concluded. For cases where disciplinary action is appropriate, we would send the case to the Attorney General's office to be assigned to an EG, and that person would file an accusation seeking the revocation of the registration or license. And typically we try to settle those as much as we can because it saves us from having to go to hearing. And that's what we use the disciplinary guidelines for, in part, is to give us terms to start with for those negotiations. And the disciplinary guidelines also go to an administrative law judge if a case actually goes to hearing. That's what the judge will use to determine what is appropriate. Some of the things that we look at when determining what we're going to do, we look at the nature and severity of the act or the crime, whether it was one incident or multiple incidents of the same or similar violations, how much time has elapsed since the most recent incident, but what the subject has done in the way of rehabilitation, and whether or not the subject has come into compliance with the law. So those are kind of the things that we use to guide us. We also use a lot of case law, prior case law, to guide us as far as what we can do and what we should do, as well as the regulations and the statute. And there's a lot of things in the law and in case law that helps guide us for how we determine cases, how we determine what we're doing, and what the standard of appropriate discipline, if necessary, is. So once we have a decision, if the case has gone to the AG's office, we filed an accusation, we have either a default decision, a stipulated settlement, or a proposed decision from a judge. Those come back to the full board, and the board votes on them, whether they're going to adopt it, not adopt it, or hold it for discussion. So the full board is kind of the final decider. So what they get that final decision, and they're making the decision whether to adopt what has been given to them or if they should reject it and come up with something different.
I have a question.
Yes.
So we're working on the disciplinary guidelines
Yes.
at this point.
Yes.
So this is where it's going to start
Yes.
to work in more into that. Okay. But you're using what is there right now.
Right.
Okay.
So what we use right now is the disciplinary guidelines that we have, which was originally written for optometrists. But they're the guidelines that we have to work with. So
Once we get to that.
And they're important, especially when it comes to any kind of settlement discussions, because and for ALJs. But for settlements, if say there's a violation for negligence or incompetence, we look at the recommended discipline provided by the board. And if I might think, okay, I'm going to do the standard terms and conditions, but the board says the minimum recommended discipline is revocation, I'm going to tell the DAG that I'm not willing to settle, because the board has already said if this happens, minimum is revocation. So those will always go before an ALJ, because I want to stick within the guidelines and then let the judge decide if it warrants deviating from the guidelines. We're going to talk about later in the disciplinary guidelines about the substance abusing licensee. If there's enough evidence from the respondent or response attorney that demonstrates that they're not a substance abusing licensee, we would negotiate settlement terms, and if it was decided not to apply the uniform standards, then the DAG would put it into their cover memo to the board to say why it's not warranted, or if the applicant has successfully rebutted it, that's why the DAG is recommending adopting the settlement without the substance abusing the uniform standards. So that's what's in place right now. But we really look at that, and whatever deviates, we have to really explain it. Or if there's somewhere on paper it sounds okay, but something could just be off. And even if you go to the disciplinary guidelines and it says probation terms and conditions, but if I'm still not comfortable with that, I would rather it go to a hearing and an ALJ, because they can hear the respondent, they can watch the mannerisms, because there's so much more to watching it in court than reading it on a piece of paper. They also can have character witnesses come in and speak to them about it. And so a lot of times I won't settle, because I'd rather it just go to an ALJ and hear everything and watch them, where with me right now it's just looking at a piece of paper and going with what the evidence is, and so it really depends. But we really rely on those disciplinary guidelines, so that I think they're really important.
And on that note, tomorrow at the board meeting, the board is hearing a petition for early termination of probation from a person who is registered as an RDO and a spectacle lens dispenser. It's actually the first one that they're hearing for the RDO program. So if you are available and you can come or watch it on the webcast, it will probably give you kind of more of an idea of what this person has gone through being on probation, and maybe give you some insight into how it is for an optician to be on probation under these terms.
And to keep in mind that probation is not meant to be punitive. It is meant, the board's not entirely certain that this person is safe to practice unrestricted. So it's a monitoring time, and to make sure that this person is rehabilitated. It's not supposed to be punitive. So it's really good to hear those petition hearings, so the board kind of gets both sides. They can see what probation has done, and if it has helped rehabilitate, or if it was just flat punitive, like that. There's so much that you can learn from those petitions, and I think it helps when you're discussing. And I think Bill has a lot of experience seeing that, and so I think that's why he knows how important these disciplinary guidelines are, because he's seen it. So it's really good to see and watch when you're discussing these disciplinary guidelines.
So are there any other questions about the enforcement program?
Thank you.
that brings us to the registration program, and it's the same update we provided to the board members for our licensing unit. The optometry side has been live in Breeze for longer than the RDO program has as far as being able to apply online. So they do see a higher volume in renewing online because it's been over a year now. With the RDO program, we don't see that because we just went live in June. And so when you look at the processing times and the statistics that I provided, it looks like really high cycle times for those who are renewing online. But what happened is that there was just, for each month, there was one application who applied with paper, and then it didn't get processed. There was either a hold on the application because they didn't mark a box, they didn't sign the document, so it was held. And then once we went live online, they applied online, and then it was processed. So it looks higher, but if we take out the outliers, there was one for each month. The cycle time went down. I think one of the registrations went down to 3 days. The other two was renewed that same day, so it was 0 days. So renewing online is definitely much more beneficial to the registrants, and we're working on just disseminating that information.
And for the optometrists, do we require that they use Breeze?
No, it's not mandated. We highly encourage it, and we keep pushing them in that direction.
And we'll follow the same approach.
Exactly. Yeah, and one thing that, and I think I mentioned, there's a new reporting tool that management has in order to analyze the workload of staff and also the workload that we get in. And one of that is with the renewals. So we can see how long renewals are taking and how many renewals are pending. So if we have, as soon as they pop up that they're eligible for renewal, we can easily identify who those people are, send out a mass email to all of them with a link to Breeze in order to renew online. So that I think will help a lot with the online registration.
So Jessica, this is for renewals only. How about the application, first time around?
So we are seeing an increase for RDOs, and I think it's on page, page 10. Yeah, we're seeing an increase in online applications. You can see that in September we received more online than we did paper, even though it's minimal for the RDOs. We are starting to see an increase.
And the processing time, let's say I just pass my ADO and I go online and I send my application.
Yeah, so the processing times are on those starting on page 10. So you can see with paper, for RDOs, for example, in average cycle times was 108 days. When you do online, it's 30 days. So it's definitely much more beneficial, and it's just a faster process all the way around. So, and we're hoping with even these cycle times, they're still longer than what we'd like, but I think with removing that notary requirement,
right,
removing the coupling requirement, it's going to be so much faster to process.
But we have to wait until that happens. They're still doing that.
Well, the board approved processing the applications without notary, so that's being processed. And after they approve it, hopefully approve it tomorrow, then we can still process them with that missing, because it was never supported by statute.
Okay. All right.
So any questions with that? All right, that brings us to the DOC RDO vacancy. So as you're aware, we still have one vacancy for the RDO member. The problem that we are running into is we don't get applicants that are technically an RDO, so they're not a president or an officer of the RDO who's applying. We have received a couple candidates that we feel would be really strong candidates, and so with help of legal counsel, really analyzing the requirement, it was decided that if we got someone from the corporation, a president, or did we say a president or a secretary? Yeah, we said president or secretary would attest to this person's ability and basically make them their proxy to represent that, then that would be sufficient to fill the vacancy. And so we received a couple applications, and then we received a subsequent letter from the president or secretary attesting to that. And so we hope to have the board members be able to consider that last position in the January meeting. So hopefully we'll get that person to join. So any questions with that? All right, so that's it of my report.
Do we have any comments from the public about the report at all?
I was just curious if the slides you just showed, I think item E, the one before this, are they available on here? I was just trying to...
Yeah, they're on our website. She's actually on our website right now.
Is she? Okay, I'm just,
Yeah.
it's my connection slow or something.
There's Wi-Fi
Yeah.
and the code is on the board.
That's all mine.
Okay, now let's move on to agenda item 5, and that's the discussion about the that national examination for Jessica. She'll tell us about that.
So members, this is, I know that the DOC had decided to proceed with occupation analysis of both the ABO and the NCLE exams. And there is another exam that's created by the National Commission of State Optometry Regulatory Boards. So this is very similar to the Association for Regulatory Boards of Optometry, which is called ARVO, where their sole mission is for the regulatory boards and consumer protection. The INSORB, I'll call them INSORB, they are the same to where they are a group of the regulatory boards, and they are looking to serve the boards and carry out their missions of consumer protection. So they have a national exam, and I provided information from them on what that national exam entails, and that was created in 2012. So when the ABO exams were, the requirement was put into place, that was decades ago, when that was really the only option to have any kind of standard examination was through the ABO. I provided some information on the differences between the two organizations. I think the biggest difference is really the mission and the purpose of the organizations. You have the ABO, who is a for-profit industry who has, who really profits on pushing a certificate. It does have its benefits because it's widely used and it is understood as the standard exams that that states require. But it is, when you look on their website, it's hard to find where the consumer comes into play, because it's really about promoting that certificate. You can purchase polo shirts with the ABO logo on it. You can, everything costs money, and I think that there's a lot of confusion just in the industry, and I think we talked about it, the differences between the ABO certification and the registration. I kind of look at it as, if the Board of Optometry, if they say the AOA, which is the Professional Association for Optometry, if they came up with, okay, we're going to do a national exam to get certified, and then the board says, okay, all of you optometrists, you now have to take this national exam and get that certificate. To me, there's a line, there's just differences. They're both very beneficial for different reasons, but I think that when you look at INSORB, it's more aligned with the mission of protecting consumers and making sure that they're all standardized. I think that there's also differences in the exams where INSORB has a practical, and I know that Ruby has mentioned that before, but I wanted to just bring that to your attention to let you know that there is another option out there. And since it's relatively new, in 2012 it was created, I think that with all the other states that are using ABO, I think a lot of it was just because that's the only thing that was there at the time. And now there's this other exam that may be more closely aligned to what the board's mission is, that we may want to consider that as well. So I wanted to bring that to you and just open it up for discussion.
Yeah, when we were talking about,
I think it was the ABO exam, it was one of them. They tested on a bunch of stuff, but there were only 6 questions or 11 questions, whatever, that were relevant to what we would care about for our licensees. Do we have a sense of what that, I saw in the memo there are percentages and whatnot, but how do they relate compared? Like, is this score exam, does it seem more relevant in terms of the actual stuff that's being tested for?
And so, I haven't done the analysis in side by side, and I think that's kind of what the purpose of the OAs for the other two exams is, to really see what they are and if they're sufficient for California. And I don't know if the committee wants to proceed maybe with an OA of this exam and the other two, or maybe just this exam. Because I don't know which one would be a better fit at this point. I think the professional members might be able to have more insight of which one appears just on the surface to be better, but I don't know at this time.
And then that would take prioritization of the OAs on, if we were going to do 3 now.
Right, or just if you another option is just to do an OA on this exam, and if it's equivalent, then look at that.
Because there's really never been one done on this, but there have been on the other one.
Well, not from the state board to do one. It's been, they do their national occupational analysis of it, but not on our side.
Okay.
When I was reading if I may make a comment, I do like that they do put a practical. That makes sense. It isn't every day as far as the spectacle. I'm curious, maybe we can talk to them and get a very specific outline of, because it seems like they're combining both exams. That once you complete this, you can dispense glasses and contacts. So that's what I want to get clear from them as well. I like that they're not-for-profit. And I do like, and I noted, and it was really good, that they put the candidates take the exam, and if they don't pass it, they don't have to pay again. They can take it again without paying. So they give them 2 times without having to pay, and that's what I really like as well. And I also am curious, because I have questions for them. Does this mean that it's going to expire? Because when I got my ABO and NCLE, I was getting notices, that your certification is going to expire, and that was confusing. So is that going to happen here?
So just on the surface, because I've only had one conversation with this woman, is really just to more educate her on how California works, because I think there was a lot of misunderstandings of just our laws in general. And so I have invited her out to come, or a representative to come. I'd like her to come with also the ABO in January, and then we could do a just question and answer session to find out the differences between the two. But I do think, though, the difference between that, as far as the certification goes, is this exam, the NSORP, doesn't give you a certification for anything. It's passing the exam. It's kind of like the NBEO, the national exam for optometrists. There's not a certification that they get afterward that they would have to renew. It's just, you met this requirement, and then it goes to the board. So there's, I think in a way too, it would help as far as the confusion for the industry, because the thought is from the applicant, okay, the board is requiring that I take and pass this exam, and I get the certificate at the end. And so they're thinking, okay, well then I must be required to renew this every single time, but in actuality the only requirement is that they pass the exam. If we went to this other side, the only requirement is to pass the exam. There's nothing from us that says this certification, and so there's no confusion of, do I renew my certification or do I renew my license? Because with this other exam, they don't get a certification that they have to renew.
So I wouldn't be getting a bill in the future, just only from the state of California to renew my registration, my license. That's it.
Yeah, because you had mentioned that when you get your certification and then you get a bill in the mail, and I don't know if you want to share that with us.
Yeah, I do have it there, and I don't know if members want to see it. And all it basically is charging me that by 2018, it'll tell me how many CEs I've completed to date, and that I should send this payment. But it didn't say anything about, when you're living in California, we recognize that in California, you're not required to keep up your CEs. The purpose to keep paying them is they're acknowledging and keeping a database that I'm keeping up certifications, but that goes against to my employer doesn't expect me to keep them up. So why am I paying that?
Nor does the state.
Nor does the state. But my employer also says we're not requiring you to, you want to do it, you're going to pay for it.
Right.
You're going to pay $250. That's $250.
Yeah, and you referenced how you get a sticker in the mail to go
That's
on
it.
your certification. And Kelly over there. So she started out being an RDO coordinator. So she knows a lot of the questions that we get. And one of the common questions she had said is people keep saying, well, I just renewed and where's my sticker? I haven't gotten my sticker. They're calling us for it because they think that we're the ones who gave them that sticker and charged them that money to do it. So they think that we are one and the same. And I think that a lot of that stems from the fact that we're requiring them to take this exam that results in that certification.
I think this goes to the core issue of, I know we're hitting the ground running doing all of these important things, but it sounds like there's such a most basic outreach and education of the regulated community that I'm not surprised every time I ask for comments from people. How does this affect you in real life? How is it going to affect you when you're on probation and you have to pay $16,000 a year for your monitor? Nobody's here to say that's too much because they don't know we're meeting today.
Right.
Because they don't know we're regulating them. And so we're doing all that. We're hitting the ground running. I think we're making good progress from what we kind of set out to do. But I think the members or the regulated community doesn't I don't want to say it doesn't have a clue, but most people don't know. If they're calling us asking for the stickers, that's a major disconnect.
Yeah.
So I don't know if we should put more. I know with our OAs there's a time factor, but that doesn't necessarily stop some of the other, prevent us from doing some of the other outreach that I think there's more value to spending the $20,000 or whatever it costs to send another mailer to everybody than to have this meeting today about updating the guidelines on how these people are going to be disciplined who don't even know that this structure exists. That's just my sense is that's what we really need to be focused on. Like I think we're making great progress on steps 2, 3, and 4, but we really haven't done step 1 yet, which is the outreach and because the way this is going, which I don't think is necessarily a horrible outcome, is we're going to, with the heavy hand, tell everybody, oh, you now have to take this new exam, and this is all we care about. So all you need to worry about is like taking the bar exam. You pass this, you're in. You don't have to worry, and just renew your thing through us. And if you're just starting out, that might be good because it's you're just starting. You don't know the difference. It just seems we're the cart's before the horse right now on all of this other stuff.
Any other comments? Do you have any public comment?
I can, there, I defer to the public, but some folks from the NAO chatted with me a little bit, and the Nixor, what do we call it, is only accepted in 4 other states of the 21 that regulate, and so there was some concern, A, about it being accepted in so few states, and then B, the mobility factor. So if the board does consider moving forward with recognizing the test, I think they want those items to be considered and then when we in the future discuss that. So I was just asked to pass that on for the National Association of Optometrists.
So yeah, we want to talk to them about mobility. What influence are they going to have about mobility throughout the states? And naturally, there are a lot of states that don't even provide an exam.
And to be fair, it's not really our concern, right?
Right.
If they move to a different state, that's up to
Moving
them at
from.
that point.
Moving from.
Oh, moving from.
Yeah.
I mean, moving from. I would assume they would have to meet the requirements that we set for our state.
But if the idea of mobility is for taking an exam in a state that doesn't have
That's right.
that exam, and you took the other exam, then you'd have to take a whole other exam. The professional options
Right.
are more mobility is better. So
Right, but at the same time, we'd be asking our current residents or current licensees to take this new test at a certain point, I'm assuming. Or I guess that's up to us. If you've taken the ABO test, you don't need to take this.
That's right.
Yeah, it wouldn't be an additional requirement
Right.
on top of it.
Right.
Yeah.
Right. So for something like the bar exam,
You need to take it.
particularly in California, it's like tough luck. We don't care.
Right.
We have a special version of the exam for a practitioner, but it's still a difficult exam. And I don't think there's the same concern, for example, with that license. You know, obviously, if optometrists have some mobility, and then we're gonna, iron fist the rule with an iron fist on the optician, saying you have to have this exam. And if you're new moving in, you gotta take it because that's our California standard. If the board wants to choose that, they can, but it seems odd that they would choose that for opticians and not have the same concern for the optometrists. And it may be that the optometrists have a better exam, or that it tests more to what we're
But there's also
concerned
more
about.
regulations of optometrists as opposed to opticians, correct?
But we're just getting started. According to the rest of the agenda, there can be all sorts of regulations.
No, but I'm saying comparing like there's more states regulate optometry than they do opticians.
Right.
So we have that we're already starting at a different bar.
Right. So for somebody who's in an unregulated state,
Right.
they are facing the same mobility issue, even though they may have been doing this for 10 years.
Correct.
They're now transferring to California,
Right.
And so you still need.
they're going to get hit with the requirement
Right.
for at least the
Well, they have,
existing test.
and they have to do it anyway.
Right.
And the way it is now, if I'm coming from an unlicensed state and I come into California, I am required to take
Right.
those exams
ABO,
right
Right.
now anyway.
But if you were in a licensed state,
Right.
your
Your
existing certification of passing the test the first time would be sufficient for us.
I mean, in theory, we could also, if we were going to allow our current residents who have taken the ABO to that be grandfathered in, that could also be a grandfathered in for someone who's for mobility's sake. I mean, that's something we could consider
Right.
as a rule, or no?
So I think the
I'm
difference there is this is a requirement for licensure,
Right.
and the requirement is that they pass this exam.
Right.
So if they're already licensed,
Right.
then they've already taken it, so we wouldn't require because it doesn't apply.
It's
to
already
them.
right. Correct. Gotcha.
So they wouldn't have to do it. But if they're coming in and they didn't take any exam
Right.
and applying, then it would apply.
Right.
But if let's say I'm in a different state and I took the ABO and the NCLE, even probably the advanced, and I come into California, would California require me to take this exam as well?
It depends on how the statute's written, but there has been statutes that allow a grandfathered in period,
That's what.
and allow the ABO up to a certain point, and then do it. But you still run into the same issue that our public brought up as far as what happens to those who have taken the ABO after that statute was in place. They still have to take a separate exam if they want to come to California.
Right. I mean, I would love to. I think I would love to hear from both both organizations as well, and also from the states that have used the NICSOR. They need. Can we also ask them to come up with a better name for their board? Something that rolls off the tongue a little better. Also, I guess my question was, what are the fees for the ABO testing?
Like about $225.
$225, and I guess.
And then the renewal.
The renewal every 3 years, $125, but I believe it's going to change after 2018. I think it's going up to about, but don't hold me to it. I think it's going up to about 185.
But
And
we don't require that.
We don't require, but
that.
people don't
Right.
understand that.
They don't understand that.
Right.
Right. We may be complicit.
Right. So don't. Don't say.
We do the outreach.
True. And then what were the fees? I was
Yeah,
trying to
there's-
scroll for the fees for this
senior,
one.
This one, I couldn't find it.
Yeah, I couldn't find it either. So
I
guess
can
that,
do some outreach and find out.
yeah,
And then-
I think that would be a question. Obviously, we'd ask them.
And how many times a year would they offer it?
ABO is twice a year.
No, see,
4
that's
times a
now
year.
4 times a
4
year.
times a year.
And when we get to the other agenda items, I wanted to point that out.
Yeah,
About-
we'll find that information out, and when we reach out to the other states, we can also ask how they deal with that mobility factor.
Right, that would be
Right.
great.
I think that's very important, Billy.
And this still applies to just the RDOs, correct?
To
With
everyone.
SLDs and CLDs.
But it does seem like I think going backwards a little to the whole question of does this have the questions, or is it asking the right questions of prospective dispensers, with 38% of the questions on fitting and dispensing compared to, I think it was 5 or 10% in
That's-
the ABO.
That's on the contact lens side.
Oh, contact lens side.
The the ABO side, it's very fair, and I was
Okay.
looking at that. It was very close and similar to what the ABO is asking, because it does have those specifications. And what I did like is that once you take this exam, it pretty much you can do both. Which is
Right.
nice.
But if you do both, I think I saw it was like a 4-hour exam if you
Yes.
did both, and 2-hour if you just want to do one or the other, correct?
Right.
Yeah.
And how long is the ABO test?
It's also same time. Same. It's 2 hours.
So it seems like they've kind of looked at the ABO a little, taken what they needed to take from that.
We may have already asked this and been given the result in a previous meeting. Are there states that regulate the industry but don't require an exam?
That would have been on the
Last-
spreadsheet.
yeah.
Do you want to have? I thought you had it right.
What was the question?
So, states that regulate the industry but don't require an exam to get a license. So they don't require ABO or...
Would you just like to know that, or if they need a practical exam as well for their state? Oh, you got the spreadsheet there? Okay.
oh, I have that right here.
Yeah.
Okay.
Is it Arkansas?
I feel like it was one, right?
There's a few. There's Arkansas, New Hampshire, New Jersey, North Carolina.
Rhode Island, Vermont, on just the NCLE.
So they don't require the test, but they still require licenses of the members. Well, some do, some don't, I see. New Hampshire, for example, has a license fee, but doesn't require a test.
And then, of course, there are all the other states that regulate them as well under the doctor's license, or the doctor, they don't take anything.
And of course, overlapping all of this is the fact that optometrist assistants doing the exact same work require
Still not
nothing,
regulated.
no exam.
Yep.
Right.
Well, their scope is broader, too, but they're under the license of the doctors.
Right. But the qualification could be child of, and then training after that.
And that's something perhaps we can talk about as we get more into the scope of practice. I know that that's something coming up as well. Do we have any other more comments for?
I think you covered it all. I think NAOO just, you know, in our conversations were that the other test is for the national standard. Some employers may hire in an unlicensed state because they have certification. So I think as you're looking at others, just sort of considering that is all that they wanted to make sure was passed along, is that it seems to be a national standard for the industry and respected by various employers.
So, Kat, you had mentioned that the industry seems, as far as employers go, moving toward requiring, was it requiring the registration or the certificate?
I don't know if the industry is requiring it. I think what I understood was that the industry standard is the ABO, the certificate. So for states that don't license, for example, but yet you want some standard when you're hiring, you would look to see if they have the certificate, for example. When you're engaging an entity that tests at such a large level, the industry will engage that test maker, test designer for the standardized questions like around contact lens that has been discussed, and they are, for example, working on that. So on certification. So I think that their only comment is that if you consider the other tests, they're not slighting the other tests. I think what they're trying to say is it's just not as well used. Only 4 states use it, and I think a couple of them are actually reconsidering that given the mobility question, because most healthcare professions are leaning toward national exams as a way to improve mobility, especially as our populations become more mobile. We move around more, so that was their only comment. And honestly, that's probably as far as I go as far as depth is concerned. I encourage you, I think it's a great idea to have the entities out to talk it through, and then the industry folks can make sure they're here as well.
If I can speak anecdotally, I've covered states with licensing and states without, and as Ruby mentioned, the test becomes more accessible, offering it more often, the online ability to get the results back quicker. I've seen more states, to your point, leaning towards that as being the standard, the minimum standard is that ABO, and looking more towards that as it seems to take more relevance in some of those other states.
Yeah, and maybe when they come, when we invite them to come and both ask, what are you doing to make this recognized in all the states? Now you're coming with a product here, basically. It's not profit, we understand, but are you working with every state to have it recognized and accepted so that it does promote mobility? I mean, that's a challenge for them too, if they want to be considered.
I would assume that if, say, we did move to this new testing, that would go a long way with other states also. If California is taking on this test, it would lend them a lot of credence as well. But obviously, we need to do right by and study if this is actually a viable test for what we need it to test for.
Right.
But we also have some time, right? So yeah, right. So if we were to switch our OA to say this instead of the NLCE, we have until July, right? So we could shift it.
Yeah. But yeah, and I'm sorry, I just really am concerned about mobility. It's an exam that needs to be national, and it really needs to be recognized through every state, so that opticians, they move around a lot. You'd be surprised, and they need that mobility to say, I don't want to take this exam again.
In reading through the material, there seemed to be an indication that California used to participate in this national organization, but that we haven't in the last 6 years.
No, so I don't know if California ever participated. when I had asked her and asked them to do research, they could only go back 6 years, and they said that we haven't participated in the last 6 years.
Okay, so we may have never participated, for
But
example.
yeah, but the only reason I found out about them at all is because we received a bill for a membership, and I didn't even know who they are or what they did, and I called them, and I called medical board first, and they hadn't participated, and so I called the board and asked them about who they are and what they do, and they had said, oh, well, California, you don't need to worry about it because it's optional to get registered, so it's really not applicable. And so I explained like the differences between the laws, and so now they want us to become members. So we're starting that dialogue.
Got it. And ultimately, nothing would preclude us from accepting more than one. It just may be a bad choice by the practitioner if they choose one that's less mobile than the other. But we may in fact be limiting mobility for those who only have the Nixor currently. So it's like two sides to the same coin in terms of promoting mobility.
And that could be another option to consider, doing one or the other, but the board approving both of them.
Right.
Exactly. Give you that choice.
We can issue a special sticker if you do both.
I'm not charging for it.
Kelly's in charge of the stickers.
Oh, no, we charge.
Okay, so any other comments? Yes, please.
Now I know it's not required for the private doctors. However, if they choose to want to take the ABO exam or the Nixor exam, and if they choose to want to become licensed, is that an option, or registered to become licensed?
I'm sorry, you said for a private, so you're talking about optometrists?
For the optometric assistants, if they want to be a part of all of this and do the examination to get registered and to become licensed, do we know if they have the ability to do so, or are they still limited under the optometrist system?
Well, I think anyone can take the exam and get that certification.
But then in terms of the licensing, are they still restricted in terms of that?
In order to dispense, fit and adjust the lenses to act as a registered, they need to be in that location in order to practice. But if they aren't using it, so if they are an optometric assistant, they aren't using that registration, they can still renew. And that's kind of what goes back to the coupling issue that we had talked about. So we aren't saying that they can't renew if they aren't tied to the location, but in order to use the services of that registration, they have to be in the RDO location. Tied to the location.
Just because at an optometrist's office, like for example, I have staff that are separate, but some of them do dispense and have to do the inspections. However, a lot of them have asked, can we take the ABO exam for the certification? And I said, well, yes, you can. However, they're like, well, what about getting registered and becoming licensed? Do we have an opportunity to do that as well? So that I don't know the answer to that.
I think, is that part of our next agenda item where we talk about the application, and so that.
Yeah, so there's no, in order to become registered, they can apply without being tied to the location. So they can get their registration. It's whether or not they use it,
And-
that's where it's tied.
And that's kind of a new concept.
Right.
Correct.
Right.
So they could.
Yeah, so there could be some commercial value to having all your optometric assistants in your practice have that $250 certificate at their workstation to make customers feel like they're getting a more getting someone who's certified, and you know, that's why they make fancy certificates for all of us. But that would be essentially the choice of the optometrist who's supervising the work of the optometric assistants. So you could get the certificate without registering with the Board of Optometry, which would be the best of both worlds, because then you wouldn't be subject to all of our regulations, but you'd have the certificate.
But you were actually asking if they could get licensed.
Because before it
They
was
couldn't,
tied to the RDOs,
Right.
and so therefore a lot of private offices have now started, and I've looked across the job boards, they're slowly wanting to require their employees become certified or have it already, just because of how the optometry field has so many turnovers now. And with turnover comes a lot of untrained staff, but then I think the last meeting we said that comes down to the employer, which is separate.
And I think we're getting a little off this agenda item,
Right.
so I think we should table that for the next.
Yeah, the next one.
next.
Yeah. Any other comments? Okay, now we can go up to, and are we doing okay with time? Is everyone comfortable? Okay. Agenda item number 6. This is where we talk about the application. And Jessica?
Yep, so before you are the edited versions based on the input that we received from the DOC at the last meeting. And so our legal counsel helped make all of the recommended changes. And so that those are before you for consideration. Once we receive any feedback, if you want to make any additional feedback, we can notate that, and still your recommendation would be to recommend that the board adopt these applications either as amended or as is to move forward with the application process.
So, as I got on board One Freeway since our last meeting, I saw that HOV violation, a carpool lane violation, has a $381 fine. When I did a casual perusal of the internet, and it looks like it's $390 now. So I think that the applications should omit traffic infractions not involving alcohol, drugs, etc. You'll see that in the we have that $300 language, and I don't know if this is because of a uniform DCA thing. If it is, then I would like to request that the Board of Optometry request of the DCA to review this for all of their boards. This goes, or when we first came on board, we talked about barriers to practice and how there was this effort to try and address those at the same time, and this is a setup for making somebody who didn't realize what would otherwise seem to be an insignificant traffic violation that they didn't report when they filled out this application, they would then become a dishonest practitioner. And the way we're setting things up without discretion to review stuff and to just follow guidelines is such that, yep, they didn't include it, so they're dishonest. So now we have a good disciplinary action we can take. That does not, that I would much rather spend all of that time focusing on the contact lens vendors. That's protecting the consumer, and that's related to the profession. And so I think, since this is going to have to be approved by regulation, I don't think we should recommend to the board that this be included in their regulation. So I would suggest we omit on all of these things the to include the instruction. I'm getting a blank screen. Okay, I found it on this one.
With a base fine under 300?
No, right. So we would say in the parenthetical, convictions dismissed under penal code must be disclosed. That's not the issue that I'm talking about. I don't know if it's great or not. Don't include stuff prior to your 18th birthday, and then say you may omit traffic infractions, and then strike the phrase with a base fine under 300. So it says you may omit traffic infractions that did not involve alcohol, dangerous drugs, or controlled substances. Now, that includes, we're going to exclude vehicular manslaughter. But is somebody who has a bad experience, not related to alcohol, a lot of those are relate to alcohol, but so this is an unintentional tragic event. But is that, do we need to know that for purposes of whether somebody can be a spectacle lens dispenser? I think when we have it, it appears that we're trying to protect the consumer and be safe. But it's really a distraction from the real work of protecting the consumers on the one thing that we have some control over, which is about the fitting of lenses and the distribution of lenses. And so I don't see it. And then there's going to be the rubber is going to hit the road that we'll get at some future meeting when we're brought into more detail on this prison industries issue, where by nature a lot of people there are going to have some sort of criminal past. Now, most of those criminal actions will still get reported because those aren't. You're not going to learn spectacle lens dispensing in prison because you had a traffic violation that didn't involve alcohol or drugs. Those people aren't in prison long enough, in my estimation, to learn the trade in the same way. So you're still going to get the important information, but just not for speeding, which in some cases you could be going fast enough to have a base fine higher than $300. From what I see on the internet, but I'm not on that stuff. I won't claim to be an expert, and if staff wants to disabuse me of what the actual fines are, then we can put it off for that.
I think this is purely a policy call. That the $300 traffic infractions part of it it is pretty standard amongst other healing arts boards as well. And as far as the discipline that would be taken, it's for convictions and misdemeanors, but traffic infractions are not included in that. So it's really
just asking more information that it sounds like we don't.
And just because they mark yes does not by any means mean we would deny or do anything. It's just really to get the information and let the staff decide. But it's a policy call.
But classically, and DCA can discuss it with their information and privacy experts, but on government forms, whether it's the Paperwork Reduction Act of the federal government or the Privacy Act, you only ask for information that you need when you're the government. And I don't know that we need this. I looked through those guidelines in preparation for this meeting, and it explains that, the guidelines will be reviewed now and then to be kept up to date and whatever. So why adopt something that's wrong or that should be updated from the get-go? It's that every time we crack those things open, we should make them better and strike irrelevant stuff and put in new stuff. Times are changing. And so, so I think this is an opportunity to do it right. And if we're the only, if the Board of Optometry's dispensing optician form is the only good one in the state, then we'll have done our thing. And so similarly, while I'm talking about the forms, there are a couple of the forms have request information for corporations, and they discuss certain thresholds, whether you're president or vice president or you own 25% or more of that, of just identifying those people. It seems to me that that those people who are identified should also be filling out the applicant form. That somebody can be an RDO and own 100% of the LLC that owns it, and avoid discipline because they're not. It's not an RDO as an individual. An individual can be an RDO, correct? If that individual gets under the current system, gets a DUI, they're gonna be required to report that to the board and go through the process, right? Well, what about an RDO that's not an individual? That's Ontario Registered Dispensers LLC. It's not a human being. So now when the guy who owns 100% of that entity gets his DUI, he might not be an RDO. He might own the whole thing, correct? And be an officer of it, be the president of it, and so he's directing everything, but he's not going to be subject to our regulations. It seems to me that those people should be licensees.
So
I don't.
So if you look at how it is right now,
Uh-huh.
for fingerprinting,
Right.
fingerprinting is what triggers the reporting
Right.
of convictions. For corporations, we have it right now and follow the pharmacy, the way the pharmacy does it. Each corporate officer is a major shareholder for a corporation, which would also be an LLC
Right.
owned by.
So
So,
they
so they
both
would be fingerprinted and be subject to reporting of convictions, like an individual sole proprietorship.
Okay.
That's as it is now. This is just a draft.
But they're still not required. They're still not licensees, though.
The entity is the licensee.
Right.
Because the statute allows for individuals, firms, or
Right.
businesses.
So the whole entity would lose its registration.
Right. My concern is that if we have a regulated scheme and we want to make sure the RDO who's in charge of the operation is good and not violating any of our regulations, that should be true for whoever's taking responsibility for that location.
And I think that was the intent of the changes that Mita had made on the applications, is to add that, have the officers be fingerprinted as well. So it is added on there right now.
But they're otherwise not subject to. They're otherwise not under our jurisdiction as licensees.
The registration is.
Right.
Yeah.
But they're not.
The corporation,
Right.
not them individually.
So.
Right.
But if they are caught with a DUI or whatever, then the entity is
Right.
would be under subject to discipline.
Correct.
That's true.
Yes.
Okay. Never mind then.
Yeah. I'm like, I think we're saying the same thing.
Yeah. Well, that
Yes.
was unclear to me.
Yeah, well, this was a new thing that we had put on based on conversations from the last meeting, because if you remember correctly, that the last meeting there was concerns that it had a case-by-case basis.
Right.
So this applied to just all officers and really mirrors the language that Board of Pharmacy does. But I do think that there's also some concerns from stakeholders on this language as is.
I have nothing further on that.
So Anna, to your question you were asking before about this would apply, so what do you think now? Here you have a private practice, and I work for you, and I ask you, and I want to pass my ABO, and I pass it. Can I apply? So your direction would be yes, you could. You could apply. But are you using it under the doctor's license? Is that the difference? Is that what you want clarification in? Because I know, because I know I am subject, because I work for an RDO. So, but if I were working under you, and I had my ABO when I was registered, and I had maybe a DUI, what's going to happen? I'm going to be under a discipline because I'm registered with the state. That's what.
Not under the RDO. So if you're working as an optometric assistant under the optometrist and you don't have a registration, then you wouldn't be subject to discipline either with the optometrist. If you have a SLD or a CLD registration and you are renewing that as you're working under the optometrist and you had a DUI, then your CLD and SLD is subject to discipline because of that DUI, but not the employer.
So really, if you work for an optician, just get the certificate and don't license with the state, because then you could be subject to, if you do get a DUI, then you're subject to losing that license at some point, right? Or whatever it would
And
be.
it's not required to.
Right, and it's not required at the very end. But this cert looks very pretty.
But you can get the cert without
Right, that's what I'm
getting
saying.
the
That's what I'm
license,
saying.
which is the best of both
Yeah,
worlds,
that's
right?
Yeah.
So that protects the consumers, right?
It does.
Well, we don't have any regulation over those individuals anyway, so.
And basically, I think what the state of California is saying, we want characters to be a good standard. That's why these guidelines are there. You're protecting the consumer. That's why we're all subject to those guidelines. That's what California is saying. Do we have any comments from the public?
As previously mentioned, when we look at the form and look at the current process, all of those things, I think there are a couple of things we'd like to explore. I don't think we have the statutory authority to explore them today, but we just wanted to let you all know that getting the signature of the president of the corporation for every single store is not an easy feat. It might seem like it, but it's not an easy feat. So we'd like to explore the opportunity to get an officer's signature. They're responsible for the corporation's requirements to meet the law, but it doesn't have to be the president or secretary who might not be available as much as an officer, another officer would be. So we'd like to explore that, but I think we have to explore that for a statutory change.
Correct.
And then the fingerprints as well. We're struggling with the fingerprint requirement, which is not currently required of our president or secretary. So we'd like to explore that as well. I think there's just I don't think we struggle with the corporation being responsible. Obviously, they need to meet the letter of the law. It's just the particular person and their direct contact with or interaction with the store that we'd like to explore. But understanding where we are in the statutory framework, I think we're going to have to explore that amongst ourselves and then come back to you all through the process. I think that, I think the last thing we'd like to explore as well, which there might be some space to talk about, is if there's an option to add a contact person for the purposes of the application. So many corporations have a single person who manages the applications across, and the renewals in particular, across the company base. So we have 140 plus RDO applications, and we have one person who manages that and makes sure that they're on time, that the paperwork's done. She's the single point of contact. That person is not listed on that It's not an option to put her down. And so then it becomes a little bit confusing. We put the officer down and that person's in New York and she's in, the officer of the company might be in a different, because it's a corporation. So.
And the administrative person who does it is not an officer.
No. Yeah,
So
the
it's just-
administration person is a paralegal in the court office. So she'd like the opportunity to be as an option listed on.
So do you have a suggestion of where that might go?
So it could go under the designated employee. The designated employee is important for the purposes of consumer contact and the board's contact should there be a complaint on page 2 of the piece. But you could put under that, and again, flexibility with the board staff is important. And I think it needs to be optional so that it's not, because it's not referenced in statute or regs currently. So you could say as an option, they could put administrative contact for the purposes of completing the application or renewal, for example.
Because for some entities, there's going to be one person who's the
Single
president, the filler-outer of the form, and the
Yeah.
doer of all work.
Manages
So
the
that-
checks, those kinds of things.
And we'll take the call.
So you
Yeah.
could put it under like, you have that section for individuals, sole, private, or partnership. You could
You
do
could put it
like
in
for
there.
corporation, like the next section could be for corporations, administrative contact kind of thing.
You could put it under the for corporations
Mhm.
section, or you could put it under the
Right.
applicant information, where we have designated employee. The designated employee is important for the purposes of who's responsible for handling
Gotcha.
consumer board inquiries complaints with respect to the business of. This is the application process, and it's a very important process to make sure we get done in a timely manner. And so making sure that the board has the right person to contact if they're missing a check or if they're missing a form or whatnot.
So the person who is submitting the signature and the date and
Right.
the testing is not necessarily the person who is going to help streamline their process.
Correct.
Point of contact.
Correct.
Yeah. So if we just add a point of contact under designated employee, I'd be hesitant to do just corporations because they
Mhm.
can apply for it
Right, an
anyone.
optional,
Yeah.
Right.
optional point
That's
of
fair.
contact.
Yeah,
Fair.
so we would just put in parentheses optional to get it through for OAL because
Yeah, yeah.
OAL would look at it and say you don't have any authority to require
Right,
this.
right,
So
All right.
And in practice, I guess maybe in the optometry world, I guess the doctors are probably very responsive, so it's not an issue. But I can imagine for somebody with maybe multiple locations in a busy practice, is there really an administrative person that we deal with on getting all of the stuff from them? So that concept might work on other
yeah,
on
it
other
definitely would help.
forms.
I think as far as staff and processing applications because if we don't know who to contact, it takes a lot longer.
Right.
Right.
And I just want to say, I think you can make it a requirement, because it says on forms prescribed by the board.
Yeah.
And if we make an argument that it's reasonably necessary, I don't think because it's not expressed in statute, I think you could make it a requirement, if it would help, if you need it.
But if they might not have it. It might be
Right.
something
Right, it might be
that.
the individual, so.
So
Just like
we'll provide something like that as optional, and then if it gets kicked back, then we would make the argument that no, we're gonna, or the board
It
can
wouldn't
make the
get
argument that they
kicked back if it was optional, because then it wouldn't be a required rule that you have to prove that it was.
So they
reasonably
still
necessary.
approve the form for everything else.
Okay.
With some,
So, perfect. So we'll get back to you on the other officers.
and Jessica, on those other two issues
Yeah.
are not within our
So she's referring to
authority. That's statutory for the.
Right, it's statute. It says in the statute that it has to be a president or principal or president or secretary. And so it's in statute, and the fingerprint requirement says applicant in the General Business and Professions Code. And so to change that, it requires legislation.
Okay.
So we'll,
What do we do? What would you like us to do? Would you
I
like
think
that?
from our perspective, we'll have an internal discussion with the industry and I think.
Then get back to us.
And get back to you.
And we should have that as a bullet point to recall it again when we come up for another.
Well, it'll come to us via the board as proposed legislation in all likelihood.
Okay.
Well, if the board proposes it, it would most likely come from the industry, and the board wouldn't have anything to do with it.
Except to take a position, support,
Yeah.
Or not.
support if amended,
Technical,
whatever.
all that good stuff.
Right. So that's how it would come to us.
Unless you all want to propose that, but even though I
That's getting the cart before the horse.
I thought I would.
That doesn't sound like outreach.
But we can talk about it.
Perfect, but on the optional, that would be great if you all could progress to putting that in the form. I think that will be helpful to the board and the industries with multiple locations.
So that'll come up tomorrow. We'll read it.
Perfect.
Okay. Yeah.
Do we need to vote?
So we make a recommendation.
Yeah,
Yes,
recommendation?
So is that,
Oh.
yeah.
We have
On your
two
point,
things.
Oh, right.
Bill's point on the traffic.
Yes, let's.
Were you still looking at just removing the, with the baseline under 300, or were you going further than that, saying you wanted it all?
Yeah.
No, I'm
Just
saying
that.
just
Just
the baseline under 300.
Well, you raise a good point though. What about like a manslaughter charge? That's a good point. Like, because that's technical, and it didn't involve alcohol or drugs.
So, in the famous Bruce Jenner case, where he was towing a trailer and hit a car that went into oncoming traffic, and the driver of the first car was killed. I don't think there were manslaughter charges filed on that, but as a result of the driving, if I'm remembering it right, and if I'm not, then so be it. But there can be scenarios where you cause an accident that causes a death, and then depending on, now every time you're going to be charged when you're DUI doing that, and you might be actually facing some, not just a manslaughter, but some other more serious homicide. So there are circumstances where it's like, yeah, it's an accident, and you in fact did do wrong, and in some counties they might file the charges against you, and some they might not, depending on the circumstances. But my point is like, that's a traffic accident. How does that relate to putting the dot on the lens when they're putting them on my face?
So I think a difference too, though, is when you start opening it up to a whole bunch of other options, you're kind of leaving it up to the applicant to decide whether or not to disclose it, versus just having them disclose it and leaving it up to the board to decide whether or not it warrants taking action. So when you can come up with these scenarios that could happen, on the other side, it really opens it up to not disclosing.
And the truth is, in the criminal law world, there's a difference between infractions, misdemeanors, and felonies.
Yep.
Here we say infractions. And manslaughter would not be charged as an infraction.
Right.
It could be a misdemeanor, in fact. Could be a felony. I think it's a wobbler. But I know prosecutors in my office have done misdemeanor manslaughters. And so, I take back my early comment, because I don't think it would be an infraction if it were charged.
So
Traffic infraction, yeah. All right.
So
Take by rate of
are you-
under $300.
So
that seems
are you
fine.
saying just to remove the $300 fine?
I'm
Yeah.
just saying to remove that part that relates to, so you say you don't have to report infractions that didn't involve drugs or alcohol or the rest of the sentence.
Just leave it $300.
Right.
Yeah.
But otherwise it says you have to report, the first part says report all of your convictions, right?
Mm-hmm.
So do we need to make a?
So I make the motion that we approve the forms, and these clarifications are for all of the forms where they
Yes.
appear. That we adopt the forms suggested by staff with the change relating to the infractions up to 300, as we've just discussed, and including an optional administrative contact field on the forms as appropriate, and that staff can make that correction and add those and then send it to the full board.
And then how about the third, about the signature? Do you want to make a motion, add to that as well?
That's a statutory
Yeah.
thing.
Okay, so
We
that'll be
can't, we
separate.
don't have authority for that.
Okay.
And the motion is to recommend that to the board,
Right, we also
which
want to
is
recommend
tomorrow.
that.
Right.
About
Will
the
you
signature.
have enough
No, the signatures, we just have to wait and
Yeah,
wait
so
and see.
we may not have enough time to change the applications that they have, and they're posted already.
Right.
But what we would do is when it came to that item, we would tell them they made a couple of tweaks, and with these, that's what we recommend.
Okay.
for them.
Okay.
Good.
So do I have a second on the motion?
I'll second.
Okay, do we have any public comment? Okay, and now I will call for a vote. Vaughn?
Aye.
Anna?
Aye.
Bill?
Aye.
And I vote aye.
I'm sorry, who seconded it?
I did.
Okay. So, it just, that was it. The signature, we can't do anything about. That we can, okay. But we will have it there. All right, are we still moving ahead? Good? Everyone good for us to move to the next agenda item, or?
Can we take like a,
Break, yeah.
5-minute break?
Yeah, let's take a
and then
5-minute
come
break.
back to
Take it
this?
back. Okay.
This is the big one, right?
Well, I have asked that we put the disciplinary guidelines at the end of the agenda.
Okay.
I think it's going to warrant a lot more discussion, and I just recommend,
Getting everything else out of the way.
right,
Okay.
and then we can work after that.
Okay,
Yeah.
good, sounds good.
Okay.
All right, so 5-minute break. Thank you. So we are back, and we are going to skip item number 7 and move that to the end, and we're going to go up to item number 8, which is about the continuing education. And Todd?
Over there.
Yeah, so remember, just to give you a quick recap, we had presented information on education requirements for what other states do, and the DOC had requested additional information, and Todd had reached out to those boards, and so he was going to give the overview of what we found so far.
So basically, in reaching out to the other boards that regulate opticians, I didn't hear back from all of them, so I was forced to do some my own research on it. But we basically took to them the main questions that we had from the prior meeting regarding if there were any sort of consumer harm that we could find related to either a lack of continuing education or a lack of mandating continuing education. We started with how many complaints do you receive regarding your opticians, what kind of complaints are they, and why do you do continuing education in the first place. As far as complaints, that was a kind of a broader question, and since I couldn't get good general complaint information from almost any of them, whether it was not public or they couldn't disclose, I was able to look up disciplinary actions, which aren't many for most of the states. I think it was Tennessee here, one of them at 11, which was a fairly large outlier. The other ones were just a handful, 3, kind of in line with what we had since over the last 2 years. Those complaints or those actions that were taken were all not even really related to education, aside from insufficient continuing education. All the rest of them were either no license, they were fraudulent on their application, things like that. The reason that they do it is fairly standard. The reason that we do it for optometrists with the board in general is they like the idea of making sure your skills are up to date with the profession. So ultimately, what it turns out it looks like is that there's not necessarily any consumer harm being caused by a lack of mandating continuing education. Doesn't mean that it doesn't serve the profession in general, but because the question was, and if the question is, are we protecting the consumer by regulating or mandating continuing education? It looks like not necessarily, but that decision has to be up to whether or not we want to go with the rationale, like the base rationale, or if we want to, as far as like the Little Hoover Commission and things like that are concerned, we want to make sure that we're not adding burdensome regulations.
And members, I also added to Todd's memo at the bottom to include the governor's veto letters from the court reporters who wanted to mandate continuing education. And I think from his veto letters, Kelly, would you mind clicking on the first here under the 2011? So you can see from his veto letter where he stands as far as continuing education. So even if we were to, it's okay, because I did take some quotes out for them. Even if we were to find an author and prove to the Assembly and the Senate that it's necessary, it probably at the end of the day would still be vetoed under this current administration. So the kind of perspective is if we are able to demonstrate consumer harm and that we do need this, at the end of the day, it's going to be a pretty big hurdle to get over this administration.
Did they try to pass the same bill twice?
Yes.
So here's my question. How can we compare court reporters? It's not a medical field, and ours is a medical field. And how are we, like the nursing and the pharmacy technician is probably where we are at. Are they required to do the CDs in the state?
I don't know about pharmacy technicians, but I think a lot of it was discussed last time about the key difference is the ones who require the continuing education are those who are diagnosing and treating. And the dispensers, the spectacle lens dispensers, the contact lens dispensers aren't doing that. And so I think that's where the difference is. And when it comes to, and I can't speak for the administration, it's just based on conversations that I've had with the governor's office and with these veto letters, it does appear that his view on continuing education is not unique to court reporters. I think it's in general. And I know that when we had a bill for optometry and we had a requirement that they take these accredited courses to get a certification, those courses stopped being offered. And so the board recognized there's a barrier because the school stopped offering the course, they can't get the certification. And so what the board did is they took that course and they put it into continuing education courses, so they still have the education to get that certification. So even it was really a technical change to create a pathway to get the certification. When it came to the governor's office, I had a conversation in the governor's office and they were concerned that it appeared that we were adding more continuing education onto it. And so I had to clarify that's not really what we're doing. We're making it more accessible to attain this certification. So then they were okay with it, but I know that everything that they're looking at, they want to make sure there's a clear reason for it.
And I can see that. I mean, even with the research you did talk, which is great. Now, there isn't really a clear reason to have it. I'm just looking at the comparison, because we are more into the medical field. And yes, we are not diagnosing, we're interpreting the diagnosis. And as such, nurses are not also diagnosing, as I understand, correct? They are also just working with the doctors. So if I were to compare, I probably would compare it to another medical profession. But if you're saying, Jessica, he's just going around and with everything and seeing it that way too.
Yeah, I don't think his view as continuing education was unique to court reporters. I think that's across the board his thoughts on continuing education. But again, I can't speak for the administration. It was just from the veto letters.
But on the research you did, it just clearly shows. And then what we have going on in California doesn't really give it a platform to say this must be done.
Mm-hmm. Yeah, I feel like it doesn't mean it's not a good idea. It just means that it's not necessarily the consumer harm.
Yeah, and it's more of an option. It gives opticians the freedom to decide. Yes, I do want to do this because I know it's going to help my profession. Mm-hmm. Just like we do anything else, we continue to get bachelors and masters and doctors because we want to. No one's making it mandatory for us to become a doctor. We just do it because we decide. So we can do our continuing eds if we decide to. Right. That's just my call.
So at this time, I guess when we brought it to you at the last meeting, we really just wanted some guidance on where you wanted us to go from here. That's when you had requested this information, and we're kind of in the same boat where we want to know from the committee what you would like us to pursue, and if you want us to provide any more information about this topic for education or renewal requirements, we're happy to assist with that. But we really just need some direction from the committee of where they'd like to go.
I think this is that CE may be a good aspirational goal for the committee, but it's more like the cherry on top of kind of all the things we've discussed, beginning with the foundation of outreach and so forth. And I think putting it off for now, we don't lose anything, because the governor's veto messages are pretty consistent on whatever the topic. Like philosophically, he's sound in his own philosophy, and so. And I hadn't heard the story about the optometrists where we tried to make it more efficient. The reaction was, "Oh, this sounds like CE," consistent with the philosophy. So I think kind of maybe re-looking at this in 2 years might be better use of our time than to come up with this great comprehensive scheme only to get rejected when we still don't know what they're testing on for new members. So I would be in favor of directing staff to put off work on this until it's kind of brought up again, or until you hear of a new breakthrough where there might justify bringing it back on the agenda.
That's great. Do we have any comments from the public about this?
Well said.
So do we have to take any action on that? Okay. So now we can move on to.
Thanks, Todd.
We can move on to agenda item number 9. We're going to go back to 7. And here we have Jessica.
So number 9 is the combining of the practice acts, and this was an issue brought up at the during the sunset process, and the board was not necessarily against it. They just had recognized that there's quite a bit of work to do as far as the statutes themselves are concerned. So the concern was it's going to make it even more confusing if we combine the acts. But they did ask. We did tell the legislature that we would continue to look at it, and I think the goal is to be able to combine the acts and the funds. We just aren't ready to do that yet, but they had asked our legal counsel to look at how we would combine the acts, and I only identified where there could be some contradictions and where there might be some overlap. And so that's what you're looking at before you. It was brought to the Legislation Regulation Committee on the 28th, and they had made some additional changes to it, and then they recommended it to go to the full board. So they have, on the optometry side, committee has recommended for the full board consideration, but since it's combining the RDO Act as well, I wanted the committee to take a look at it and see if they agree with the LRC recommendation to go before the board. There are some outlines of what changes were made, but a lot of it is technical. A lot of it is copy and paste into the applicable law sections. The one that was changed was the rulemaking authority, because that's really the rulemaking authority for the board. So it would just make it easier, since we have so many regs that are pending the rulemaking process. If we could cite one rulemaking authority versus all the other rulemaking authorities, it would be a lot easier. But other than that, a lot of them they're non-substantive changes. We didn't want to make any changes at this point to the statutes themselves. So, Mina, if you want to, I don't know if you have stuff to add.
I think, unless you want me to go through the detail, I don't know if you have any questions, I'll entertain questions.
So the purpose of this task is really just a cleanup to consolidate, not a time to address the big picture issues that are addressed by the acts. For example, whether certain professions should be regulated at all and maybe stricken from the act altogether.
Right.
So when I look through it looked like a merged document. My one question I had is I have two. In the definition sections, it looked like they really only have the definitions from the Optometric Act, and I'm wondering if any consideration was given whether we needed to include their optician or opticianry or any of those things that might have been in the other act.
I didn't delete any definitions from the RDO, there's a general provision. I'm not sure that there
So
were
do the definitions appear in two places, not just up at the front?
So I don't think, as far as those acts that were pulled from the RDO sections, if they're not in here, they didn't exist. And so I think the issue with no definitions, I think is just an issue that's always been there.
So there's not some other statute where it
You might
defines.
be thinking of maybe the prescription lenses or because we didn't merge the prescription lens statute, because that's going to stay under the medical board.
Got it.
Well, it's
section
under,
in the-
so it's actually under both. We have dual jurisdiction for the prescriptions because ophthalmologists apply to it as
Right.
well. So we didn't touch that section.
Okay. And then the other one I had, I guess this isn't the place for it because it's more of a substantive issue, right? So like, tell me if I'm on the right track. There's currently a section about harboring contagious diseases that only applies to optometrists, but not to the other professions. That sort of cleanup is a whole different effort.
The only intent of this is to combine the acts and consolidate when absolutely necessary, like the rulemaking authority. But that was the only intent for it.
And then I had just like some clarification. I don't know that we would want to look at it now or at some other time, but like on pages like 60, it's defining that opticians are certified. I'm just curious, are we looking that we are certified or licensed? It's just, I don't know if
Did we
that's
decide
important. It did say certified.
I think
Like in page 60.
I
you
think
know.
one of the issues was going through and making it consistent to say
Yes.
registered.
Right.
Okay. But I don't know if Jessica thought that was more of a substantive change that we didn't want to do at this time.
Right, it's displaying the license, not the certificate.
Yeah, I don't think those. I don't know about. I mean, you're our counsel. I don't see those as substantive changes. I see those as
Just
cleanups
wording,
that
yeah.
we could put in here.
Right.
At this time.
At this time. And then on pages 68, 71, it did say that if an optician is not practicing after 5 years, they would be asked to retake the exam that is offered 2 times a year, but you know that's changed. Currently it's 4 times a year. That's page 68, 71.
So what has been done in the past with these types of technical cleanups is you could make a motion to approve this and then delegate authority to myself and our legal counsel to make any technical non-substantive changes.
Okay, so we can do that then. All right. Does anyone want to? Because right now the ABO and the NCLE are offered 4 times a year, and it does say that it's only offered 2 times a year.
Yeah, so not meaning to stop discussion, but
Sure.
while we have the idea on the table, I'll make the motion to recommend to the board the proposed consolidation as presented to us, and suggesting that the board authorize staff to make non-substantive cleanups to this consolidated revision. Is that the sort of?
Is that what we're looking
Yeah.
at? We got that. Okay, does anyone want to second that motion?
Second.
Okay. Any further discussion from the committee about it? Any from the public?
I'll just continue my usual public comment. I think as long as it stays in the realm of technical in every sense of the word, I think we're comfortable. Again, we're continuing to fold out 684. Haven't met all of our, we're still in the rollout phase, so I think anything that is less than technical would be considered substantive, and we probably want to dive in and figure that out.
Yeah, and my hope is that if we remain purely technical and just the moving of the acts, we can get it into an omnibus bill and get it pushed through relatively easily. And so I would recommend not putting any kind of substantive stuff in here at this time.
But the more we can clean up certificate to license,
Yeah,
display,
right.
the less we have to do when it eventually comes time
And I agree that
to
that would
fight
be a
for stuff.
technical.
Yeah.
And how would you like us to get you that information that we see? Because I have just there.
If you have technical amendments, you can send them to me. And I
Okay, we'll do that. Okay, so there is something, and we have a second, right, on this motion? Okay, should we call a vote now? Okay, Bill?
Aye.
Anna?
Aye.
Con?
Aye.
And I vote aye. Okay, and just more on this discussion on page 54, and you kind of tell me, I just kind of bring out only from experience, because talking about the contact lens seller on page 54, and I don't know where this would, when I was reading it, it's talking about, they have 2 days to notify. Let's say I'm going to buy some contact lenses, and the contact lens seller needs to verify my prescription, and they have 2 p.m. verification next day and all that. I think there was even a discussion about that. Is this something we would talk about now? And also identify who they are requesting it from, that they clearly identify who is the prescriber, because if a contact lens seller is contacting me, I am not an optometrist. We do not write prescriptions, but that patient came and bought contacts, and they truly believe that I can verify for them. And so I wonder if somewhere in there that the prescriber really needs to be identified, and that's something we need to discuss now.
Yeah, I think that'd be a substantive change that may need to occur, and I think that the board, as part of the strat plan, was looking at that 8-hour rule as well. So I think it is going to be discussed. I just think as far as the intent of this change is concerned was not to include substantive changes, and I think that one warrants further conversations.
That's all I have. Any more comments? Any more comments from the public? Okay, then we can move on to our last item. We're going to move right back up to agenda item number 7, and that's the update of the guidelines.
So members, we have the guidelines in front of you, and I'm asking for Kelly to bring up the Word document so if we can go through it and make any changes to the document. When going through this, I think that the initial thought was, well, we can just use what we use for optometrists, and while on paper a lot of the optional conditions make sense because we could make them work, in practicality, when you put these conditions on a registered spectacle lens dispenser or contact lens dispenser, a lot of them just don't make sense to put onto these individuals. And so what I recommend doing is I put some comments on to give examples of what we need to really discuss to see if they're necessary. But a lot of these, I think, still require more work and consideration. For example, the standard terms and conditions include a quarterly report. Well, that quarterly report applies really to optometrists, and so that would need to be developed for the RDOs, and to have that, they would have to be developed and incorporated through the regulation, so you would need to really discuss that one. Also with a worksite monitor, while there might be a benefit to adding a worksite monitor to a person who's fitting and adjusting lenses to have that person monitor to make sure they're doing it correctly, there's a benefit there, but when you look at the worksite monitoring plan that optometrists have, it doesn't apply to what you would want for a worksite monitor for a person who's fitting and adjusting. So that's a completely separate document. And I had, when we developed the worksite monitoring plan for optometrists, we had a sub work group to help develop that and then bring it forward. And so that's really what I'm recommending for these other types of documents, the worksite monitoring plan, the quarterly report. If we could have the DOC delegate authority and request a work group, and it could be anyone that the work group delegates. I had mentioned, I think, have the chair and vice chair work together to come up with a plan to present to the committee. I think that would be more beneficial than just applying a lot of the optional conditions. I think we need to reconsider applying to the dispensers. And so, are there any questions? I provided quite a bit of comments on each of them. I think this is the worksite monitoring condition that I had mentioned, is going to require more work to really decide on when these conditions should be applied and what that plan looks like. There's another one that I think I put a comment on for restricted practice. And okay, so this one is for direct supervision that she's on. And what is it right now? The direct supervision, the supervisor has to be an optometrist or an ophthalmologist. And well, I could see maybe, but is that really the person who you want, who needs to be supervising this individual? And at what violation would warrant a direct supervision type thing over someone who's fitting and adjusting lenses? So if that's warranted, maybe consider who that supervisor should be. There's another one. You want to scroll to the next one. Remedial education. So this is another one for optometrists. There's a difference between the continuing education that they go to and the remedial education where they're sitting down in a classroom and we require them to take a specific course. But for a person who's fitting and adjusting lenses, is there really a course that they would be able to benefit from specifically that they wouldn't be able to get by doing a continuing education course? Because if we feel that the violation, they need more education, is the same outcome, the same result? Can you do it from just continuing education versus this remedial education, which is a lot more difficult to do? So that it's really a discussion for.
Well, we don't have continuing education.
Right.
Correct.
And there's not an education requirement in the first place.
Correct.
And we don't want to start, if in the future we're going to deal with it, we don't want to say, well, the only time you do a continuing ed is because you're under some sort of discipline. So you want to call it something else. That's another concern I have.
There's another one on the next slide about the restricted. So this is the worksite monitor that I had mentioned, the worksite monitoring plan. This is something that I recommend the DOC developing and not using what we have for optometrists because it doesn't apply. The employment limitations, really consider what limitations those would be because it might not really apply to a person who's just fitting and adjusting lenses.
And I see you've highlighted some of this. So those are the ones you would like to see. The ones that are
Those
highlighted.
are examples. I think the whole document, each condition, I think should be gone through and just make sure that it serves the purpose of rehabilitating the individual and not serving as punitive. Because I think a lot of these, when it comes to just the vast differences of scope, and while these aren't, I believe, necessary for optometrists, when you look at the limited practice that dispensers are doing, it might be viewed as more punitive to apply a lot of these onto them. So another example was the restricted practice. For optometrists, we could say something to the effect of they're not going to treat and diagnose glaucoma, or they have to have a person in the room when giving exams, or we restrict them of what they can and cannot do within their scope. But when you're looking at the spectacle and contact lens dispensers, their scope is fitting and adjusting lenses. So what else are you going to restrict them to do? If you don't think they should be doing that period, then you wouldn't be putting them on probation. So what else are you going to restrict them from? You know what I'm saying? So I think a lot of these conditions we really need to just kind of hit the brakes, and it hurts me because I want to do them, but I want to do them right, and I just don't think that putting this in as is going to be the right thing to do.
Does anyone else, any members have comments?
Well, I have comments on the document as we
Yes.
go through it. Or
Well, but are we talking now about maybe putting a work group together to go through the document? Because it is going to take time to go through it, do you think?
that's true. We still have a little bit of time, and I think it would be good to discuss some of these philosophical issues, you know, as we go through them. And even if we get through the first 10 pages, I think it sets the tone, and it might be that that helps direct any work group, or we can continue doing it next time and take baby steps. But the idea of doing it right the first time is better, especially since, you know, quite frankly, a lot of things that Jessica thought of, I hadn't thought of, and it's like, oh, that makes a lot of sense. If you're, how do you restrict the practice? And I don't, maybe in the practice you have insights that can say, oh, that there is a way, but.
Ruby, to clarify for the work group too, I agree with Bill. I think that each condition should be discussed as the whole committee and with public here to get the participation. The idea of the work group is really just to develop the worksite monitoring plan, to develop that the quarterly report, rather than work on that now, because we really don't have anything, so it's more conceptual. It works more efficiently, I think, if we can work on those documents separately, but I think each of these conditions should really be done with the full committee, which is why I requested that we put it toward the end of the meeting, because we most likely won't get through all of them today, but I think it's necessary.
Okay. You have any comments from the committee? Yes.
So I have a comment on page 5, which is the first page of the text, in the introduction section. It's more of a question. I want to, in the 5th paragraph, it talks about the board favors outright revocation of the license period. If, however, respondent has demonstrated a capacity to practice optometry safely, the stay is a stay revocation order. Do we want to change that to opticianry? Was the, I didn't know if that was just a philosophical statement of how the board handles it, or if something that we meant of how they're going to handle this.
Yeah, so are we doing this separately?
It's really an introduction just of the board as a whole of what we do. But yeah, we should add, many times we mention optometry, we should add opticianry as well.
And opticianry.
Yeah.
Because this is going to be the combined.
No.
No,
It's
yeah,
gonna
so
stand
the
alone.
idea is to keep them separate for
Okay.
now. I think initially we were thinking they could
Right,
be
right,
combined,
right, right,
but it
right.
would just
Right,
cause
gotcha.
too much
Mhm.
confusion. So
Fair.
Kelly, did you catch where he wanted to add an optometry? Yeah, right there. And a lot of those types of changes we'll continuously go through and try to catch as well through all those reviews. So I'm not too concerned about the technical, it's more of the policy.
And on the same, so on paragraph 7, so 2 paragraphs below that, the board, let's see, 1, 2, 3, 4, 5, 6, 7. So the last paragraph, the board recognizes that they are merely guidelines, and the aggravating and mitigating circumstances and other factors may necessitate deviations from these guidelines in the particular case. I'm wondering if we want to add to that sentence to say, and the board has to agree to this anyway, that the board encourages the Office of the Attorney, the Executive Officer, the Office of the Attorney General, and Administrative Law Judges to use their discretion in applying these guidelines.
The board encourages.
So it would be, my proposed language is the board encourages the Executive Officer, the Office of Attorney General, and Administrative Law Judges to use their discretion in applying these guidelines. So much of what we hear is it's like, this is what the board told us to do, you know, my hands are tied. But I understand these are guidelines. The whole point of guidelines is to be uniform, but
Sorry, I'm slow.
Yeah.
that's fine. These happen in the real world,
Allow for flexibility.
and there needs to be flexibility. And what reminds me of this is there was I think it was a sentencing guideline, because I read the governor's veto message, because that's all I read this year when all the things came out. I was like, what did he veto and what did he have? Why did he do it? And so it's like, oh no, this is tying the hands of judges. That's what we have them there for. Let them use their discretion. We don't need a new crime. Let them figure out where this fits into the system. So my language again is the board encourages the Executive Officer, the Office of the Attorney General,
Tell me
and
the thinking on the right side.
I wish my computer told me where to put the plug. So I can't see how far we got.
Attorney General.
Office of Attorney General and Administrative Law Judges to use their discretion in applying these guidelines.
Administrative law judges to administer.
To use their discretion in applying these guidelines.
Sorry, I'll go back. Everybody don't look at me. Sorry, okay.
I do still think that any deviations from the guidelines, because I agree that it definitely should be used, it just needs to be explained why this deviated.
Right. I think that comes up later, no?
Yes.
Did we talk about that?
And I think with the uniform standards, those have to be used in the substance abusing cases. But I think it's fine to have this as a general introductory.
Right.
part. I would just say it's also the board that uses these guidelines in their decisions. So I'm
Okay,
wondering if we
so
could
maybe
say
we should. It's the board encouraging themselves.
Yeah.
Right.
So, but the idea is that when I was on the board, everything already took place when it finally came to the board. There was a ribbon on it, and it was presented, and you voted. You accepted, rejected, or modified.
Theoretically, if you rejected it, you'd be able to then change everything.
Right.
But
So we could say that the board recognizes its authority to use their discretion in applying these guidelines and encourages.
you know what? You already have the board. You're right in the first sentence. So let's
Okay.
stick with, and the board encourages the Office of the Attorney General,
Got it.
the Administrative
Yeah, you
Law
had
Judges.
it. Yeah.
You're right.
That's,
All right.
that's
The
right
board
there.
says-
So to see that?
Yeah.
Anybody else have anything on that page? I have something on page 6 that follows.
Okay.
This is for, in paragraph 2, citations. This is on the next page.
I think you had it.
Page
Go back
6
up.
of the
Go
board
back up a
packet.
little more. Sorry, I don't know why they.
One more page up.
Yeah.
There you go.
Good.
I would add to the citation section. In this, I was going to add it to the back of the paragraph, but maybe we could put a space and just have this sentence alone underneath that first paragraph. Something to the effect that the board believes that most first-time violations can be addressed with action less than administrative discipline, comma, such as the issuance of a citation. So my idea here is that
I can always go back to the podcast too.
Yeah, well, we'll see if people agree to kind of the concept, and then I'll repeat it again. The idea is that not everything needs to be referred to DOJ for administrative violation, and as much as you will hear, and I have heard throughout my career on both this committee and the board, it's like, oh, don't worry. The first time DUI violation coming home from your sister's wedding, not related to practice where you're not coming or going to work or whatever, that's not gonna result in these very thorough probation conditions and all of that. That's not gonna happen. In experience, it's like, everybody, if you think about it, if you were in the position of being the government employee and your mission was to protect the consumer, it's like any violation, you're not going to make the mistake of being the person who does not push it as aggressively as possible. And so this acknowledges that that employee, the executive director, doesn't have to kill every fly with a sledgehammer.
But haven't we already done that in the very beginning with your first?
That's true, but this isn't the citations comment. This is to acknowledge that you want to know what? We have a great thing. Like, for most of this stuff, you would think, like, just saying, hey, you did this, I'm a public member, what to a Joe Public thinks is an insignificant paperwork violation or a totally unrelated criminal violation. It's like, hey, we're your licensor and we're watching you. And so, if this happens again, you're getting the whole book thrown at you. It seems to me, because particularly in the wedding DUI scenario, these are people who go to criminal court, get the AA condition of probation. They get a substantial fine. They probably have community service associated with. They get punished for their wrongdoing, and the whole point of these is not to add punishment.
Right.
And so, for a lot of these first-time violations of little things, it's like we need to be stern with the citation, maybe not just a warning, but this is the most important tool the board has in addressing lapses of licensed members, and this highlights really to staff that that's where the board's coming from.
Can you repeat your?
So my proposal is to say the board believes that most first-time violations can be addressed with action less than administrative discipline. That's where we get the AG involved and file those complaints in the ALJ and all of that stuff, comma, such as the issuance of a citation. This being in the citation section.
And to clarify too, and really to give an example, and even with citations, we could say, yes, the executive officer has the discretion to pursue a citation, to pursue discipline, which is true, and it should be used. But you had different people who come in over time. And for example, I know of one board who decided that for every time a licensee didn't update their address of record, they would get returned mail. Well, by law, they have to update their address of record. So they clearly didn't. So that board, the EO was using discretion to apply citations in every situation. So as soon as they got return mail, there were citations being issued. Here you go. You didn't follow the law. Would I have done that? Probably not. We probably would have done some little outreach to that individual, try to find them to get it updated and educate them on updating their address of record. But it really could go any way. And I think Bill's concern is, yes, you have discretion, but how do you make sure that that discretion is used responsibly and not abuse that discretion?
This is really more more guidance from the board,
Setting policy.
right, as a matter of policy to staff, and that you don't have to
Throw the book at them.
go with administrative discipline on every little thing. And I don't know that that happens now. My experience in the past is that sometimes I think that has happened, and given the measures we require, then if when you're sitting there, it feels like punishing the person for something that, by the way, you'll see when they talk about the ALJ or when we get to mitigating factors. The time since the violation is a mitigating factor. That seems virtually ignored because violations don't come to the board until, it seemed in my experience, 3 years after. So the person had their encounter with the law 3 years ago, resolved it all criminally, and then finally it comes to the board 3 years later. And it's like, well, first, from society's perspective, they've made amends and are, and so in the context of somebody fitting and dispensing lenses, 3 years later, to then answer to some of these charges and then be put on probation and all of these things. I don't know that's always considered that way. And part of this is in my opinion, some of the insurers, because when the violation is that a doctor would defraud the insurance companies by selling sunglasses but calling them prescription lenses or whatever to get the retail sale. And so they'd be $200,000 of fraud against the insurance company. So what the insurance companies would do is let them work off, pay back their debt with a nice practice, and as soon as they paid off the insurance company, then the insurance company would file a complaint with the board so we could take discipline on them, because the insurance company didn't care if that person ever practiced again because they already got their money back. But it they weren't concerned about the consumers until after they got their money. And so sometimes that led to delays before the board would actually hear about it. So,
I don't want to go too far, but right up on bullet point number 3, up on top under probation monitoring focus, where on bullet number 3 it says allow for the education of individuals as to the responsibilities, requirements, and professional mandated of opticians. So what is mandated as far as education for opticians?
I think that should just be removed. I think we did a search for optometrists and replaced it with opticians, and that
mixed it.
Yeah,
we
so
don't
that
have
should
any
just be
mandated. So that's
so when we go through this, those are the technical type of changes to make sure that all of them make sense.
Okay.
You guys just want me to keep scrolling?
Sure.
Yeah.
So I have something on page 7, mitigation.
So don't scroll too far, just go to the next one.
Evidence of mitigation, number 4. No prior criminal or disciplinary history. I would add to the end, add after history, related to opticianary.
2 pages up, Kevin.
The heading is Disciplinary Guidelines 2017.
One more.
Yeah, go up a little bit more.
There we
Right
go.
there.
So number 4 on the bottom there. No prior criminal or disciplinary history related to opticianry. So just add related to opticianry.
I think you want to go down to mitigation of discipline.
I'm sorry. The next, you finish that and cut and
Yeah.
paste, right? And then add that to the bottom, to number 4 on the bottom, the very bottom.
Under evidence,
There you
yeah,
go. After history. But it should flow as one sentence. So little n, no period. Again, for some of our possibly for some of our future practitioners, there may be criminal history, but that would automatically be counted against them almost in this context. They wouldn't get the benefit of number 4. And what we should really care about is the criminality and disciplinary history as it relates to fitting lenses and dispensing.
Well, and that is an overall for convictions in general. They have to be substantially related to the profession.
Right,
So
but as you know, then the legislature has defined specifically some things that are
Correct.
related to the profession automatically, and so again, this lets the ALJ, for example, understand that this is the first time I've ever been before you for this discipline.
Right, because we've talked about, or we're going to be talking about people who've been in prison and do
Right.
not want to be. So how are you going to hold them to that? Yeah.
And then I have nothing until page 9.
Whoa, slow down.
I'm just saying.
Does anyone else have anything before page 9?
But our pages are different. Wait, so this is my page 9.
Oh, mine is 9 of the package that was of the agenda item. So it's probably page 3 pages less of, or 2 pages less of the actual guidelines.
And the other one has the packet.
I have the memo on top.
and that doesn't.
Right.
That's why we're off.
I'm sorry. So it's the first. It's section. It's called Uniform Standards Related
Right
to
there.
Substance Abuse and Disciplinary Guidelines.
Oh yeah. So we do have at the last meeting. That you had expressed that you had some concerns, and so Mina did do some additional research for this section.
Kelly, it's on the desktop. There's another Word document.
On the right, yeah, right there.
Okay.
What's on there? Yep.
Yeah. Okay, so members, you had asked for some sample language, and I put together what I found were the 3 options that boards use to define basically what a substance abuse and licensee is, in order that the uniform standards would apply. So the first one is a presumption, and it's the Board of Optometry uses this. In any case involving drugs or alcohol, the licensee is presumed to be a substance abusing licensee, and then they can rebut that presumption through the administrative hearing process. I have some considerations after each one for your consideration. This is very broad. It applies in any case involving drugs or alcohol, even if there's no abuse. I think there's some examples of the wedding or the one-time DUI.
Right.
And then it requires a licensee to rebut the presumption, and the licensee sometimes represents him or herself, and they may not realize that they can do that. So, but that's one option you have. The second option is the option that is in the uniform, the draft on page 9, and That's the clinical diagnostic evaluation. So that would be after a decision is made by the board, after a hearing, the one of the orders would be that the licensee gets a clinical diagnostic evaluation. And it's expensive for the licensee. But the pros is that you have an expert opinion about evaluating the licensee and coming up with the conclusion, this is a substance abusing licensee. But it's additional burdens on the licensee. Do you have any questions on that one?
This is the option that we chose originally, right?
But I think you were having second thoughts about that. And the examples I've seen that requires the licensee to also go through, have 30 days of negative drug testing as well. And they would be prevented from practicing during that time.
And that's part of the uniform standards.
Right.
So because a clinical diagnostic is required, then they would have to stop practicing during that time and then test negative for 30 days.
And the last one is that, this is a sample from the dental board. Oh, the previous one is used by the dental hygiene committee and also the physical therapy board. The last one is a dental board actually uses. The burden in this case is that the complainant, the executive officer, through the administrative hearing process has to prove that the licensee is a substance abusing licensee. So the burden is shifting compared to number one. And that gives the licensee the benefit of actually having, rebutting, not rebutting because there's no presumption, but having the case be proven with evidence in the administrative hearing process. And it wouldn't add extra costs on the licensee because they're going through the administrative hearing process anyway for the violation.
But that also means then that you wouldn't be able to settle any cases involving drugs or alcohol if you're going to do an accusation. You wouldn't be able to do a settlement, I don't think, because this is after a notice of hearing of the ALJ to prove it. So it might hurt some settlement options.
Couldn't you settle it without the substance abusing determination?
I think you could settle. I think you could get an admission that they have a substance abuse problem,
Well,
just like you would in other cases.
That would be one, but you could also say, okay, your DUI is professional misconduct, but and you agree to professional misconduct and 3 years of probation and blah blah blah, but it doesn't have the substance abusing 16 or whatever they are. They're just left off of the settlement.
You can still settle.
You only need to prove it if you're seeking to include those terms of probation, it seems. What I like about that one in looking at this is, besides the fact that the dental board uses it, is that it would allow us to remove item number 2 from the next page, which speaks to the weakness of option 2, which is the person's removed from practice during the decision-making progress, which is onerous and I think by not having number 2 as the option listed currently as subsection 1 here, then you don't need item 2 in its bullet points, correct? Because there's not a corresponding, that language doesn't correspond with this.
You'd actually just replace the D on page 9 with whatever section you want to use, number 1 or number 3.
So number 3, right?
Right. Well, I think number 3 makes the most sense now. And is that sometimes this might go through like a hearing with the ALJ where they make the initial determination and all of that. It doesn't have to go to the full board every time somebody's.
In order for the board to adopt it, it would always go before the board.
There would have had to been a hearing.
Correct.
And
Yes.
so that's
Yeah.
99% of the time it's going to be before
Right.
the ALJ.
Right.
And the ALJ would say in their proposed decision, for example, the evidence proved that.
That they are or they aren't,
They are.
and.
And
okay.
one tool that the board has, if we did have a concern that there was substance abuse, we could do an 820, compel them to do a psych eval, to do that, and we could use that as evidence in hearing to say
Right.
there is a problem here.
Right. And again, that's going to be alleged when the facts warrant it. When it appears that way, they won't be shy about pushing for that.
So 3 actually gives a lot more flexibility,
It does.
right?
Yes, it does.
Yeah.
Because it gives that.
Which is what we had thought to
And,
it.
and in
Right.
my sense, it gives more kind of due process
Yes.
Yes.
to the applicant. The public will remain protected because it will be determined whether they're a substance abusing professional or not, as opposed to just automatic. And so we would put language 3 under that section little d.
Yeah.
Is that,
Little-
or the section D up top, is that right?
On page 9, yes.
It's not that I know.
Right, so we're taking out the clinical diagnostic evaluation.
And putting it
Wait.
That whole,
through.
well, it's a whole like 3 sections, right? 2
Right.
sections. Because we're not, there's no removal.
Hang on.
Clinical diagnosis, yeah.
You just, let's see, you're just taking out D, because the
Right.
first 3
That's
paragraphs.
Yeah,
right,
threes.
the one I highlighted.
Yeah.
Yeah.
So actually go back to her document.
I copied it
Okay.
and then just pasted it right there.
Just change the A to D. And I have to find out, that something that.
Find out
those
what
3
the,
dots,
yeah, what those extra,
They weren't.
Yada,
substantive.
yada, yadas
I think
are.
it said, I know what it said. It said after notice and hearing pursuant to, and it listed the code that's
Okay.
relevant for the administrative hearing process.
okay. And
And so then would you remove all of number 2, removal from practice?
well, you would also remove number 1. too.
1 and 2
One
then get
and two.
removed, right?
And we need to replace that with whatever the wordage would be for administrative hearing, right?
Is there any more besides what's
Wait,
there?
where?
I'm.
No, if we go down,
Go
if you,
down.
No, so
Clinical.
then you would not remove those because those are the uniform standards that
oh,
you put on.
gotcha,
Yeah.
okay.
So we don't touch those.
We don't need to touch those.
Right.
So those.
But it doesn't
those
even come,
apply-
it doesn't even apply at this
Those
point.
Right.
Right.
Those only apply
If-
there's
if-
a
Oh, I
final
see the
decision.
point
Right.
now. I thought that was, we were choosing
Right,
and
right,
then
right. Yeah, yeah.
got it.
Okay.
And so,
Okay.
in
so-
terms of making the document better, now these are uniform terms, but it seems to me that this is where the rubber hits the road on, is removal from practice during the evaluation the same thing for a,
No, not when it
Administrative
comes to
hearing.
the uniform standards, we cannot touch. I do know that there's a couple that are under consideration to be revised, uniform standard 4 specifically, but when it comes to the uniform standards, we can't make any changes
Right.
because this is uniform.
So what is,
it's uniform to DCA, to the
Yeah.
state,
No,
to,
to all of DCA, the healing arts, the uniform standards apply.
Okay.
So we can't
To every
change
healing arts.
those, but after the uniform
Okay.
standards, when it gets to guidelines, that's where we can change it.
so,
so do we need to put in, but the administrative hearing element isn't here, is that something we need to then
No, because
input
it's
as a uniform?
it's already clarified that it says when we're applying the uniform
Okay.
standards, so as soon as that trigger that we're applying them, then we can't touch the uniform
Right.
standards.
Okay.
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 So then we're going to be able to skip over
Right.
that section. So I'd just like to say that I think we should, if this document moves forward, we should recommend that the board requests DCA to do a comprehensive review of the uniform standards. I had many concerns. I'll raise just one. I think that the board should be able to grant a temporary, in section 4 on the testing schedule, should be allowed to grant a waiver to anybody subject to testing for a period of up to 2 weeks per year. So they can leave the country if they have to, or go to another state if they have to, or whatever, without this burden. To me, I don't think the document should go forward until those changes are made. I understand that how the votes may happen to send this document forward, so I'll probably be voting against it. So my only suggestion is that the board be asked to request the DCA to do a comprehensive look at these uniform standards.
And number 4 is the specific one that I know is being
Right.
reassessed.
It's being discussed right now.
Okay, so then what do we move to from here?
It does need to, because there are a lot of changes to that, yeah, I can see.
So we would go to, it's page 16 in our packet, probationary
yeah.
terms and conditions. And I don't think there's much for this. It's really just model language of how the conditions are laid out. So unless you have any, it's really once we get to conditions, standard terms and conditions. And we have 10 minutes left, so I don't know if there's a specific one you want to address right away.
What page are you looking at?
We're at 17 in our packet.
Yeah.
Right, starting with number 1, obey all laws.
Mm-hmm.
My question was on number 5, continuing practice as an optician. I know it seemed like, and for optometrists, almost like a catch-22 because it's hard to get work
Yeah.
when you're on probation,
Right.
but we require that you be actually doing the craft while you're on probation. But there's no education requirement, so you don't have to remain sharp on the skills. Technically, we don't require that.
Right.
Otherwise, we just require that you would have passed the test. And so, for this profession, is being, in the office 60 hours a week or doing whatever really necessary while, let's say, during your probation, you're doing all the other stuff to get your life in order and your act together.
So I think the thought process at this time, because this was one that, were you there with Dr. Goldstein when we were talking about this specific condition? I don't know. But anyway, so.
I remember Dr. Goldstein.
Yeah, this came up a lot because it's difficult for probationers, especially when they're placed on probation. They're kicked off insurance panels, and so they aren't able to find work, which becomes they're not working. It's a violation of probation. So it was difficult, but the thought is going back to the intent of probation and demonstrating that they are safe to practice, that they are rehabilitated. So if you get someone on probation and they aren't doing anything within their scope, how do you know if they are rehabilitated because they haven't been doing it this whole time? So I think that was the idea, is that you want them to be able to demonstrate they are safe to practice. And that's the reason, but I don't know if that applies to someone who's fitting and adjusting, or if you want to make that an optional condition.
And the other thing is, in this field, the person who was previously a dispenser might, while they're on probation, go work as a optometrist assistant, no?
Well, they wouldn't be, for this, they could do both, but if this condition is in place, they would have to do both.
That's my point.
Yeah.
And so it's like, oh great, I got fired from my first job because they don't want somebody on probation. The place where you could find work, which is, to that person, the same work of, even though they're theoretically, they could do much more as an optometric assistant, they're only being employed in the lens shop or whatever they call it, or the lab or however it works. And so they're doing the same work, which it seems to me would satisfy the goal that that number 5 is seeking, no? That they keep on doing, functioning, doing the work to stay sharp, presumably.
Right. And because they need to. Because after 5 years, if they're not practicing, then you have to retake the whole exam. I mean, I don't know how
Right,
long.
but they might only be on probation for 3 years, and so
Right.
they work for the optometrist
Right.
for 3 years, well, and then they're going to
They're fine.
petition for early.
Yeah.
So, so what was Dr. Goldstein's recommending?
Oh, he wanted them to work. He wanted the 60 hours, them working, and to show it. And the board at the time as well. And I understand it.
And then the other question is, and maybe the public can help us, is it's 60 hours per month.
Per month.
So that's probably within the realistic amount of somebody who has the job, that they'd probably be doing it 15 hours a week.
Right.
Is that realistic? If you got the job, you would probably be doing at least twice. Well, see, I don't know. Is this one of those jobs where they, like in the mall, do they employ people 4 hours a day have them work 19.5 hours so they don't have to pay benefits, or what?
Yeah.
I don't know how it works.
Because we wouldn't have them not pay benefits. I think the question is, what's the flexibility of the schedule?
Oh, so but realistically, people are working 15 hours a week if they have this job classification.
At least.
Yeah.
Many of our employees are full time.
So it's just whether they have a spot or not.
Yeah, it would be really hard to have someone who's working hours.
Could we say or equivalent work? Doing the same exact thing in a optometrist's office.
So instead of an equivalent, because that kind of leaves it open, you could say act as an optometric assistant pursuant to, and then this section that lists what they can do.
Yeah. Yeah.
That's
Then you're
more
really defining-
comprehensive.
Yeah.
And it addresses our concern, right? That they're staying sharp in their trade.
Yeah.
So I recommend that we add that.
Number 5, right?
Yeah.
So after dispenser for the different licenses that it says, you would add or optometric assistant as defined in 25.
If I have the right, I understand your terms and
She wants to put it up in the list.
Inside the brackets.
Yes, no, so go down to number 5, the actual verbiage of it. Yeah. So after the brackets, you would say, or an optometric assistant
Pursuant to.
and I don't have it off the top of my head, but it's 25 something, but I'll know what it is.
Right. So my next comment is on number 9. If nobody else has anything before that.
Oh, the valid license status.
Valid license status. it mentions CE requirements,
Yeah,
which we don't have at this time. So is it just failure to pay all fees?
Yeah.
Prior to his or her?
Yeah, and number 11, they are, they surrender the registration, but still they can go and practice under someone else's registration.
Yeah.
Now, under the sale or closure, so there are opticians that do own their own practice.
But if it's less common, an option is to make it optional. So we would only apply it if they own their own practice, but you also run the risk of, and it happens now where you have an optometrist who might not own the practice now, but during the course of probation does get their own practice. So this would apply. So.
Right, and in that same number 14,
Yeah.
the last sentence refers to optometry.
Okay.
The provisions of this condition in no way authorize the practice of
So that's
opticianry by the whatever the to practice as an RDO or RSDO or
Yeah, that's
whatever
better.
By respondent. So we just list the 3 types maybe.
right. It's the SLD.
To practice
CLD.
as an
SLD.
RDO, SLD,
And CLD.
and CLD, or CLD by the respondent.
Practice out. Right there.
I actually don't understand the need for that last sentence at all.
Okay, so maybe we can delete it.
Take it
Let's
out.
see. Okay, so the provision says if you sell your office or your practice,
So that means you can't work wherever you sold it to?
because you can work under somebody else's license.
As an optician, yes.
But you can do, but so you, I think deleting it is fine.
I was just trying to figure it out.
Yeah. Yeah.
There's a lot of things in this document. It's like Christmas for me. So.
Yeah.
It was strange.
It didn't feel like Christmas reading this during the baseball games.
It was damaged, I know.
It is fine.
Yeah, because we can.
You want to continue?
I only have one more comment.
Okay.
On page 23.
What
Oh.
condition?
Yeah, so this gets to number 16, the biological testing. So it relates to the standard condition. I wanted to add similar language granting the board authority to give waivers on the for up to 2 weeks. So is that something we wouldn't add until?
Yeah, non-disciplinary uniform standard was, number 4 was touched. But we could, Kelly, if you want to put a note on this to apply the same, any changes to uniform standard 4 to make sure it corresponds with 16.
Right.
Yeah. Those were all your comments in general, or you have
No,
more
there's
we
more.
should wrap
No,
up?
that's
There's-
it.
Really? That's all?
Really?
Okay.
Wow.
I mean, there's more work to it.
Well,
I have more.
I was picking my battles. I had one big one and I lost. So
For now, it's just on
You didn't
hold.
lose per
No,
se.
it's just postponed.
But you did
Yes.
win.
You ran away very quickly.
Okay, so do we have any other comments about this? And we're still going to be working on it after.
Oh yeah.
Okay. All right, so now.
So-
Comment.
Oh, the public,
So
we have the
sorry.
public.
Yeah, no, no.
There's still work on this.
Oh yeah.
Just really quick. On farther down, on item 34, the pre-examining advertising optician during the direct disciplinary process. I think we need that to, I think we need to review that in the recognition of all the advertising requirements for an RDO versus an optician, etc. Because advertising is a national law. So, how would you? It seems like overkill, and we were trying to figure out how would you manage that. So,
And then it's down in optional conditions too, so it wouldn't be on any standard, so it would really be on the committee. Another conversation we have to have too is once we get through these conditions to create the recommended discipline. So we really have to discuss at what point and what that looks like for the recommended discipline. So the restrictions on advertisements, the ones that I've seen that we've placed on it, it's been a while, was when we had an optometrist who was doing some misleading advertising. So one of the conditions was we have to see and approve it prior to him posting. For the respondent, not him hiring versus.
Right, and these are from the choose menu, right? So not
Yeah.
everybody gets this,
Right.
so.
yeah, we were just trying to figure it out.
Yeah, logistically how
Yeah.
How do you manage a national lie
Right.
when you're working for Walmart?
Right.
Yeah. The fact remains that it is there. It's a possibility.
But we
Yeah.
wouldn't delete it, we'd just clean it up.
Yeah, we have to.
Yeah, it just play out how that works practically with the corporations versus the individuals and what that looks like. But I think each one of these we have to go through and at what point the DOC would recommend placing this discipline on it.
Exactly.
And it should be opticianry.
Yeah.
Okay, and since we're going through these, we can return back to a couple of these, but number 36, continuing education, I think that goes back to the earlier comments
Yeah,
about
with
continuing education. And then number 37, a medical records course, keeping course. So we don't, medical record might be the wrong term for this one because you take a record of the length, the frame that they might have selected. You have the only requirement of the FTC is that you keep the prescription, but there's not really a medical record like we would use in all other terms of medical field. So I think we need to re-examine, and then doing a record keeping course seems.
But do we have another condition on record keeping?
Yes. So there is, and we can maybe address the issues that would come up for opticians in that one versus this
Right.
one. But this is another example of when we initially went through them. I think one of the questions asked was, is this really? Do they even maintain these records? And I think another member had said yes, it could apply, but it wasn't really thinking like, okay, what really this specific, because it's a specific course, and how it would apply to the opticians, and is it realistic to apply this condition on someone who's fitting and adjusting lenses and not really maintaining all of the records. So I think there's just better ways to address the same issue.
And the only records that we keep, yes, it's the prescription, but also what they bought and the measurements and the lens material.
Yeah,
But we could do that in the medical maintained records. We can maybe tailor that to what we would want to look for versus this one.
yeah.
This is a side question. Are dispensers involved in the insurance fraud, or do they just get the script and fill it?
Well, yeah.
But in some cases they could be in on it, I guess.
They could.
Okay.
They could.
Never mind.
They could.
Yeah, because you're billing the insurers
we
for
are.
the frame and lens product, so
Got it.
They could be part of what's going
it depends on where they fit in the business.
Right.
on. And a lot of times they're just
But it could happen.
Yeah, exactly. Depending on whether they're fitting in the business. Yeah, exactly. So if they're the optician who's actually billing the insurance versus if they're putting information in the computer and something happens. Right. Goes awry. The other thing, and this is what I think, again, the retaking of the exam, this is on number 35. Sorry to go back up, but the retaking of the exam versus the drug rehab issues, and sort of, is this connected? But it sounds like you all are going to talk about the drug rehab issues going forward. So, is drug taking? So it requires that you take and pass the ARBO exam, but then there was a question, I think, later in the drug rehab. Number 35 is fit in under drug rehab. So I guess the question that the person who sent me this one had was, does it make sense to take and retake the exam when you're doing drug rehab? I don't know. It just was they were both. The way that all these numbers are connected has to fit with the disciplinary procedure you'll use. So I think they wanted to put a pin in that.
Because the ABO, that has to do with the job. It has anything to do with the drug.
But this seems.
Is there a comprehension issue?
Maybe I'm just missing where, at what point it's tied into the drug rehab.
So they're looking at all the.
Because these are all the
maybe you already
options, right?
fixed it. Here. So you have.
Oh yeah,
all
so
these sections. If you go down to page 44, you have all these sections where all these numbers fit in.
yeah, the if warranted. So
Yeah.
all of the recommended guidelines, it has to be completely rethought.
Okay,
That we're going to talk about that in a separate meeting to go to come up with recommended discipline.
Yeah.
So because a lot of these don't make sense to apply.
So that was yes.
Yeah.
So I got a fair amount of comments. I got some comments. I picked those out.
Yeah, but overall, the recommended discipline that starts.
This is all stuff we have to read.
Yeah, and I put a comment on there too that these are just examples of how it would play out, but it's for optometrists.
Right.
So when the DOC considers this, it's in this format. You consider what's required and what's warranted.
And I think they just wanted to put a pin in that. It just rose to a level of, is that appropriate?
Right.
I'll put pins in every single one of these.
Right.
You could take their pen, take all mine. So.
Right. So that was, I think more or less it's when, I think the question is when would that retake or take and pass or retake the ABO or
But in optometry, it's not uncommon that appears in for every single violation
For the law exam.
for conditions of probation.
Yeah, it's a standard condition for them to take the law exam.
Right.
But for this one, it's pretty uncommon for this to apply to optometrists for probation.
Because it's their practice exam, so an optometrist doesn't go back to school and take their boards again.
Right.
And take their California
Because they don't have a
exam.
law exam.
Exactly.
Yeah. We don't have a California
We're not.
exam.
Yeah.
It's 5
Yeah, we don't know.
Yeah.
Question 1.
Okay, thank you. Now just our last item is, do we have any future agenda items we'd like to add?
So this is a work in progress still.
Yeah, we're
We're
still
not
working
making
on
a
it.
recommendation for tomorrow.
No.
Right.
Do we have any future agenda items? Do we have any from the public? Okay, well, if we don't, is there anything else?
I move we adjourn.
Okay.